Is it on? Okay. Welcome to the March 28th regular meeting of the Calaveras County Planning Commission. So we are now in session. Let's take a few minutes and do that sweet flag.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
And it looks like we now are all here. We're happy to see you. And do we have any agenda changes today?
No, there are none.
Thank you. So we're going to start a short public comment period. The public may address the commission on land use issues not on the agenda. 5 minutes per person, 15 minutes per topic. Is there anybody who would like to say anything this morning? Seeing none, we'll move on to the consent agenda. There are just 2 items on it. Approval of the minutes of the last 2 meetings. Can we do those together?
Yes.
Does anybody have any comments?
I gave a couple of corrections, typos to Annette Silva, so I assume they've been done.
Great sword. So is there a motion?
I move to approve the minutes for the meeting February 28th and March 14th.
Thank you.
I have.
Is there a second?
Second.
Thank you. Any discussion? All in favor?
Aye.
So we are going to open the public hearing for a zoning amendment for Victoria Teller for lot line adjustment 1720, which will relocate the common boundary between 2 parcels by merging a portion of a parcel zoned timber production with a parcel zoned rural residential, 1.3 acre minimum parcel size. The LLA creates a split zoning that must be resolved by way of an immediate rezone from the TP zone. The portion of APN 24-133 merged with APN 24-134 and APN 24-134 from RR 1.3 to residential agriculture. The remainder of APN 24-133 will remain in the TP zone. The subject parcel is located at 1810 Love Creek Road in Arnold, approximately 3.5 miles northeast of the intersection of Moran Road and Love Creek Road. APNs 24-133 and 34 are a portion of Section 34. 5N, 15E, MDM, a negative declaration has been prepared pursuant to CEQA guidelines, and that was way long. Wow.
I don't think I need to say anything
We don't need to do that anymore, do we? We can do the short summary version.
Okay, so we'll just kind of zip through this real quickly since Michelle's pretty much already stated it. Kelly, you want to hit the lights for me, please?
Well,
You're on the end now, you're the light monitor.
Before we get to that, I think we had another item on the consent agenda, which would be the minutes for March 14th.
We did them both together.
Oh, okay.
That's good. Okay. As Michelle just stated, before you today, you have a zoning amendment for Victoria Teller. Zoning amendment actually comes as a result of a lot line adjustment that was proposed to merge a portion of a parcel that's zoned TP, timber production, with a parcel that is currently zoned rural residential. The purpose of the lot line adjustment is to alleviate the trespass of residential improvements that were supposed to be built upon APN 24001034, but actually encroach over onto the adjacent parcel 24001033. The property owner, Victoria Teller, owns both pieces of property, which makes it a little bit easier. However, as a result of the lot line adjustment, we now end up with a split zoning that is causing a bit of an issue. So as previously stated, the parcel is located at 1810 Love Creek Road in Arnold. This is a version of what the lot line adjustment was proposing. You'll indicated in the different colors. The blue parcel down to the south happens to be the rural residential portion parcel, and the remaining colored parcel is the parcel that is zoned timber production. Most of us understand the purpose of the timber production zone. In short, the assessor's office actually assesses the value of the land for growing and harvesting timber as being the highest and best use of land. So there is a different tax rate as a result of that. And when we're combining the two parcels, it creates a bit of an issue for the assessor's office. Their recommendation to us with the lot line adjustment was to rezone a minimum of that portion of land that is being merged with the rural residential zoning zoned parcel to alleviate the difference in the assessed value of the property. So trying to determine what zoning we're going to zone the property, we originally, of course, we go right to the general plan to see what we have as far as available zoning is concerned. And one thing that we noted immediately was a difference in the land use designations. So the parcels are currently governed over by the Avery Hathaway Pines Community Plan, and the merger of the two parcels will actually create not only a split zoning, but will create a split land use designation. Isn't that much of an issue, except we're trying to find consistent zoning to zone the newly created or configured parcel became a little bit cumbersome. So you'll see the proposed parcel A actually will include a portion of property that is currently designated resource production, and the green portion down towards the south is the portion of land that is currently designated rural residential. So comparing the two different land use designations, the Avery Hathaway Pines Community Plan finds consistent zoning in each land use designation. To kind of process of elimination, I went ahead and identified the consistent zones that match up between the two land use designations, and I came up with timber production, rural home industry, and public service, none of which actually make any sense for the newly adjusted parcel because the parcel itself is not in timber production. They're not managing the parcel for its timber resources. There is no rural home industry on the property, so that would be an inappropriate zone district, and it's obviously not public service. So if we go to the current general plan, there's a provision in the general plan that indicates all resource zones are consistent in all land use designations. And our resource zones, as we much understand, are general agriculture, agriculture preserve, general forest, timber production, in addition to residential agriculture. So once again, went back to the Avery Community Plan and identified those resource zones in each one of the land use designations, and came up with ag preserve, general ag, general forest, again timber production, and now we have the inclusion of residential agriculture as a compatible or consistent zone district in the rural residential designation through the community plan. Took it one step further, went ahead and looked at the future. As we all know, we're under in the process of a general plan update. The general plan update map has designated or projected this land to go to a working land designation. And again, we're not making findings of consistency. It's not required as far as approving the zoning, but I think it is important for us to take a look at the future plan and see exactly what's out there and what we might be creating as a result of taking action on a zone change. So again, the general plan update has this entire area that's in that chartreuse green color is all working land. So consistent zoning in the working land designation will be general agriculture, agriculture preserve, general agriculture, timber production, and again, residential agriculture. Now, I think we can all do a process of elimination and determine that the existing property and the use are not really compatible with zones such as general agriculture, which is our primary agricultural resource zone, agriculture preserve, which is in conjunction with the Williamson Act, general forest, which is pretty self-explanatory, and we all understand what the timber production zone is in terms of managing our timber resources for harvesting timber. So again, that leads us down to the residential ag zone, which seems to be the most compatible zone for the newly configured parcel. So if we take a look at the bigger picture, I found that residential agriculture was the most appropriate zone in regard to the intent and the intent of, what does the property owner, what does she intend to do with the property in the future? Well, it's residential. It is residential. She doesn't intend to do anything other than residential uses, maybe some small-scale personal farming activities such as gardening and whatnot, but really doesn't have any plans for the property other than to simply live there. The purpose of the property provides an equal emphasis on agriculture and residential alike. And in addition, the zoning actually is consistent with the current general plan in that all resource zones are found compatible in all the land use designations. In addition, it will be consistent with the general plan update once we get to that point. And it is consistent with the rural residential designation in the Avery Hathaway Community Pines, Avery Hathaway Pines Community Plan. Say that one 5 times fast. So upon your request, we completed an initial study. Circulated the initial study and negative declaration. We found that there was less than significant effect on the environment. Circulated the document for public comment. We did in fact receive one comment letter, and that was from Mr. Gibson. And his concerns were basically that the zone change would then set the property for future development in terms of land division. He thought that by zoning the parcel residential agriculture, the property owner would then have the ability at some time in the future to come and ask for a parcel map to subdivide the property, creating additional parcels. His impacts that he stated in his concern letter were legitimate if that were to be the case. However, that's not the case. Love Creek Road is designated as an F-level service, and the general plan would not allow any parcel to be created less than 40 acres in size on an F-level service road. So regardless of what we decide to zone the property, this property being the size that it is has no potential for further land division, and it will simply just be used as a residence, and we will not be creating any additional parcels, therefore creating additional impact out in the Love Creek area. Understanding that, he has withdrawn his concerns, and subsequent to that, we didn't have any other concerns regarding our determination of a negative declaration. So in short, our recommendation to you is basically we're finding that the residential agriculture zone is appropriate for the newly configured parcel. It meets the purpose and the current and intended use of the property. In addition, the residential agriculture zone district is consistent not only with the current general plan and the community plan, but also with the general plan update. So therefore, we're not creating, if approved, we won't be creating an inconsistency that would then need to be rectified through another zone change. So our recommendation to you is that you recommend the board approve the RA zone for the merged portion of this parcel, and we will be retaining, our recommendation to you is that we retain the TP zone on the remainder of that larger TP zoned parcel. And that concludes my presentation.
Thank you.
I just want to thank you for the thoroughness in which you conducted this whole thing, including the initial study and all the comments involved. And, you know, I really appreciate the fact that you do look at every factor and consider it and tell us
We try.
what it is.
Is there a representative for the applicant here today?
Mike, please.
It's on.
I don't
Speak up. Okay.
I don't see Ms.
So-
Teller in the audience. I don't know, we must have had a miscommunication. She was aware of the meeting, but perhaps she obviously doesn't live in San Andreas, and I know she has a business in Sonora, so perhaps she was detained by other things.
Do any of the commissioners or members of the public have any questions? Okay.
I would just ask, out of ignorance, sorry, does the RA have a minimum size to it?
For newly created parcels, if we were looking at a land division and we were actually creating parcels, then there would be a minimum 5-acre parcel size. And that would be the same for rural residential zoning as well. There is no public water, there is no public sewer out here. But again, with an F-level service road, we wouldn't be talking about anything less than 40 acres if in fact that's what we were looking at in terms of land division. But we're not creating a new parcel. We are simply trying to rectify the trespass by doing a slight merger of the two. So we feel confident that there are no minimum parcel size required issues.
And with a lot line adjustment, if we, as long as we're not creating anything smaller than existing, so if we have a substandard parcel size, and in fact both of these lots are substandard, as long as we're not creating anything smaller than what already exists, that's the standard that the county uses for approving of a lot line adjustment. So that in this case, the smaller parcel, the 1 1/3 acre, is getting larger. So it's moving it closer to the minimum parcel size we'd like to see for well and septic.
Thanks.
Any further discussion on this item?
I'll have a couple of suggestions on the resolution when we get there.
I think let's go ahead and hear the suggestions.
Okay, some I already gave to Gina, but a couple I didn't. In the fourth whereas clause, it says, whereas the planning department of the county of Calaveras analyzed the request and recommends the parcels be rezoned to RA, residential agriculture. I don't think that's quite correct because not all the parcels are going to be rezoned. I think it should say, whereas the planning department of the county of Calaveras analyzed the request and recommends the parcels, except for a portion of APN 24-133, be rezoned to RA.
Thank you.
And the only other one I didn't give Gina was just a,
That was the third whereas. We removed the word "are" in the first sentence. So now it reads, whereas the proposed project is located on real property in the unincorporated portions of Calaveras County, more particularly described as portions of APN 24-001-034 and 034 or 33 and 034. It used to read are located. We omitted the word are. Makes much more sense now. Located at 1810 Love Creek Road. And the other was under the third finding. It was actually labeled as number 2, so we had 2 number 2s. So we changed number 2 to number 3.
And I came up with one more.
One more?
Under,
You didn't call me.
I didn't catch it till this morning. On page 2 of 3, under paragraph 2, on the evidence, second sentence starts off reading, the RA zone is resource zone. Should be an A between the is and the resource, and that's it.
And your new finding 3 starts with a typo. The word "the" is
Yeah.
spelled with a 3.
Yeah,
We fixed that.
Oh, you fixed that? I didn't know you fixed that.
Anything else?
then I think we're,
Should we close the public hearing?
yeah, let's close the public hearing. Any further discussion?
No.
Are we ready for the motion?
Yes.
Staff recommends the Planning Commission approve Resolution 2018-051, recommending the Board of Supervisors approve the zoning amendment from timber production to rural residential 1.3 acre minimum parcel size to residential agriculture for a portion of APN 024-001-033 and APN 024-001-034.
So moved.
Second?
With the motion and a second, is there any further discussion? All in favor?
Aye.
Was that Tim on the second?
Yeah.
Thank you.
Let's move on to our next item, which means I have to find my agenda. So we have an appeal by Thomas Tryon of the Planning Director's determination that the Angels Gun Club is a legal non-conforming use. And Peter.
Moment to get settled here, if you don't mind.
Before we get started, I need to announce I'm recusing myself from this matter because I am a member of the gun club, and so I have to pack up and leave.
When you recuse yourself, yeah, so leave, right? Okay.
And if I could interject a question as to whether anyone else in this in staff or the commission is a member of the gun club. And how that does or does not affect.
I'll be honest, I had been a member of the gun club. When I saw the conflict coming, I let my membership lapse. I would also say that I don't think that by Commissioner Wooster leaving, that doesn't necessarily mean that there is a legal conflict of interest just by being a membership of the gun club. I don't think that actually rises to that level. However, Commissioner Wooster feels that it would give the appearance of a conflict of interest, and commissioners and board members frequently recuse themselves when that happens.
Okay, so this is an appeal by Thomas Tryon of my determination that the Angels Gun Club is a legal non-conforming use on APN 64-005-031, 64-006-007, and 64-006-008. I don't have a fancy PowerPoint like my staff does. I just have a couple of key slides I want to show up. Most of the information is in the various staff reports and documentation that you've received. As noted, this is a public hearing, and the rules of the Planning Commission regarding such hearings should be followed. In this instance, while the burden of proof that the use is a legal non-conforming use falls to the gun club, Mr. Tryon is the appellant, and therefore he should proceed with his testimony following my introduction. Property owners of the use in question should then be able to make their presentation, followed by public comments. There's a couple of things that I believe that we can all agree upon. I don't think there's any question that a target shooting organization is operating at the gun club property, or that the use is a target and shooting range. The bulk of the improvements and activities associated with the range are located on parcel, I'm just going to refer to the last number, 08, which is the larger parcel where all of the facilities are, including the clubhouse, the parking lot, trap shooting stations, and the pistol range. The rifle range is located on 031, and 07 is vacant, except that spent shot falls on that property, and therefore is considered part of the shooting range. I also believe that all parties agree that the use I just described was established on all parcels prior to 1986, when the county adopted its permissive zoning. What I mean by permissive zoning is that only those uses listed in the ordinance as either permitted by right or by a use permit can be allowed on the property. If the use is not listed, it is prohibited. Furthermore, I believe all parties agree that parcel 08, which is zoned recreation, allowed for a targeted shooting range under the general classification of hunting and fishing clubs until that provision was changed in 2000, at which time a conditional use permit was required for a targeted shooting range. The issue before you is whether you concur with my determination that the use has not expanded as that term is used in the ordinance since 1986 on parcels 031 and 007, or since 2000 on 008. I provided in the staff report and the addendum the provisions of the code as it relates to non-conforming uses, and I also have these up here on the screen. Under 1704-010, no land use may be commenced, enlarged, or altered unless it is permitted in the zone. 1792-020 states that any building devoted to a use not permitted shall not be enlarged, extended, reconstructed, structurally altered, or reoccupied without approval of the Planning Commission. If you find that my determination is accurate, then the gun club can continue to operate as it has without enlarging or expanding the use indefinitely. However, if you find that my determination was in error, and that in fact it should have required a use permit, the gun club has the options of either scaling back to where they were before, and we'd have to make that determination what was considered not an expansion, or they could apply for a use permit to allow continued operations they have, or an expansion of what they have. Based on a site visit, my review of the aerial images, and statements made by the president of the gun club, I determined that no such enlargement or alteration occurred. I'm going to sort of briefly go through some of the aerial images I have and point out how I made that determination. So this is the earliest image that we have. It comes from 1998, and you can see, where's the little arrow? It's a little fuzzy, but there are 5 trap shooting stations, one here, one there, 3, 4, and 5. You have the clubhouse, the parking lot. This is, the pistol range is here. You can barely make out the little building. Why does it keep jumping up? The little building there, and the rifle range shooting station is here. It's unclear where the target exactly is, but it looks like it's probably right about here. The next image we have is from 2002. This is much clearer, better images, but again, you can see the 5 shooting stations, pistol range, and again, the rifle range there. There are a number of existing roads on the property, and these sort of remain the same as they were back in 1998. The next image is from 2010. Again, you can see the 5 shooting stations, though it looks like 2 of them have been somewhat abandoned. Maybe they're just not as widely used. They've planted some grass. I think they paved some of the surface area. This road has been re-gravelled for better access, but essentially everything is in the same location as they were before. In 2016, again, we see pretty much the same thing. And finally, the last slide I have is from 2018. There's been some earth movement and clearing around the shooting station for the rifle range as well as the target area. Other than that, everything sort of remains the same. In my review, I looked for changes that increased the capacity of the site, increased the size of any structure, or made a change that created a new effect on the surrounding properties. There was ongoing maintenance and safety improvements made, but I do not believe that those rose to the level of expansion or enlargement of the use. I do not intend to go through a point-by-point refutation of all of the issues raised. I will leave that to the gun club and to the appellant himself to raise the issues that you will need to consider. He cited, I want to address one issue, however, that the appellant has brought up. He cited to a number of court cases addressing issues of amortization of non-conforming uses and the findings of the courts that the purpose of those jurisdictions' ordinance was to eventually remove those uses. We do not have such provisions in our code. Our code allows for the continued use of a non-conforming use, certainly, essentially in perpetuity as long as it doesn't expand. We do not have a provision where we are looking at trying to eliminate those non-conforming uses. Different jurisdictions have different standards. Ours has allowed that they may continue indefinitely as long as there's no expansion. With that, I will open up any questions that the commission may have.
Well, one question I have is, we were looking at this whole thing as a unit, but really we have 3 parcels, and we could have a decision as to one parcel that it was enlarged and such, and whereas another parcel is not. Is that correct?
Yes, that's correct.
And if the gun club had no right to use a particular parcel, such as the parcel that was just used for the falling of the shot and this sort of thing, but they used it anyhow, that would not give them any non-conforming use, right? If there's been a question raised as to whether they owned it, and
I do not know what arrangements were made with the prior owner. They may have been leasing it. They may have just had a gentleman's agreement to allow that to continue on. Ownership does not necessarily matter as far as use. The fact that they purchased it after 1986, as long as it was being used for that purpose, and that the owner at that time had no problem with it, I don't see any reason why that would preclude the ability to.
as long as they had a right to use the
Yes,
property
yes.
one way or another. Okay. Now, the definition of structure in the zoning ordinance is quite broad. Structure means anything constructed or erected, the use of which requires attachment to the ground or attachment to something located on the ground. For purpose of this zoning code, the term structure includes buildings, but does not include swimming pools. And then the definition of building is simply building means structure. So I'm wondering, as far as you mentioned lighting, which I assume was attached to the ground, concrete fingers, and if you could describe what you meant by concrete
Well,
fingers.
the fingers are, as you see in the picture,
Those fingers.
those fingers. And I'm not a shooter, so I don't know how that's used, why that alignment, but it seems to be fairly common for all 5 of the trap shooting stations. So maybe they set that. I don't know. Maybe someone at the gun club can explain how that's used more.
Yeah.
If that's of interest. But Those are the fingers that you can see there in the image.
And are the trap houses, the what appear to be roofs behind those fingers?
These,
Oh, those are the trap houses. That's where the clay is shot from, is that right?
that's my understanding, yes.
So, but all these things, the lighting, railings, trap houses, and fringes, why wouldn't they fit within this definition of structure?
We consider structures those things that require a building permit. And so if it's less than 120 square feet of roof area and does not have any power or water to it, does not require a building permit. I think that there is some level of flexibility or grayness there given the sort of circular definition that we have of structure and building. We don't typically require a permit for flat work, for concrete work, for driveways and walkways and those kinds of things. The structural, if it was an addition to an existing building, for example, we would consider that a structural change, a new building, obviously.
And do you know, was power required for these trap houses?
I don't know.
I guess, well, you've just described what the practice is of the county, and I'm just not clear on how that fits with this remarkably encompassing description or definition of structure. What are we to do with that?
Well, I want to go back to the original picture, and it's pretty fuzzy, but I think you can see that there were existing trap houses, like there's one there. This is not a very high quality picture, but if there were trap shooting going on, they had to have something just to fire off the clay pigeons. So I didn't see that as necessarily being an expansion of the use.
Yeah, well, I'm just hung up on this definition of structure.
Right, I understand that.
And I'd take any help I can get on that.
So the commission is going to have an opportunity to discuss this more later. I'm wondering if we shouldn't let the applicant begin his presentation and hear from the gun club's representative, and then we may have even more questions. Are you okay with that, Tim, or are there things you want to get out now?
It might be helpful to the parties to know some of the things that are of concern. So if, you want to go back to the two ordinances you were trying. If it were determined that either one of these ordinances had been violated or in violation, who decides what the remedy is? I mean, you mentioned how they could just drop back or...
Well, it would be ultimately a decision by the property owner of which option they want to select to remedy the situation. So if you find, for example, that a use on one parcel is not grandfathered, is not legal non-conforming, they could simply discontinue that use. Or they could apply for a use permit, and it's up to them to decide what course of action they wish to take. Or if there was some structure that was added that you found, no, that needed, that raised to the level of expansion, and therefore either you can remove that structure or apply for a use permit for, to.
But is it clear that they would have the option of just decreasing their use to what was permitted?
Yes, I believe so.
And here, although 17.92.020 and its title talks about use. Really, the ordinance itself only talks about structures or buildings, et cetera. But the ordinance at the top, 17.04.010, does talk about use and is talking about enlargement of use. As I understand it, why your interpretation is a mere increase in the usage of, say, the trap shooting would not constitute would not take this out of a permitted non-conforming use. And yet, I don't see how increase doesn't amount to enlargement of use.
Looking at it in the context of other types of legal non-conforming uses, the numbers of participants can vary, from day to day, from year to year. If you have a legal non-conforming commercial building, or say a retail store in a residential use, how would you control the number of customers that they might have? I'm sort of use that as an analogy that the fact that they may have higher participation, larger membership one year to the next, it probably fluctuates year to year. Again, to me, it's the capacity of the site to handle that amount of people. Have they done something to increase the capacity, added another shooting station, for example, or...
But adding another shooting night would not be a problem?
If there had been a restriction that said, back in 1950, you could only shoot 3 nights a year, and then they added a 4th, I would say yes, but we didn't have any such restriction. So there was nothing in the code, nothing based on the original use that said they could only shoot for 2 nights.
But isn't the restriction actually the whole practice of the non-conforming use is that there can't be an enlargement of that use? That's the restriction we're here.
Well, and I guess that's, I will leave that to the commission to decide whether or not. I did not find that an increase in day-to-day operation was an enlargement of the use. That they could have very well had 5 nights a week or 5 days a week of shooting previously, and it can fluctuate based on the activity level and the interest in the gun clubs.
And finally, the idea of more customers that you have no control. Here, you have a membership, and you do have control over an increase of use. And so I'm not sure of that analogy.
It may not now be the perfect analogy, but that was the way that I looked at it.
Okay.
I think we're going to discuss that later. There was actually some information about the number of members they have and what they had previously and what they have currently. So if that's going to be a metric, I think we can discuss that later after we've heard the presentations. Anything else? Okay.
Can I ask one question? I mean one. In addition to what Commissioner Laddish has mentioned, the word altered shows up in 1704.010 and other places, and I haven't heard you mention that as a consideration. I don't know what that means. Is it defined anywhere else? Just altering something sounds like it could be anything.
That's a good point. Again, I looked at it. Does that alteration? I mean, you've got ongoing maintenance of anything that needs to be done. Is that considered an alteration? So, painting the building an alteration to keep it from falling down. If you've got some repairs that are necessary. Again, I looked at it in the context of, did it increase the effect on neighboring property owners, the alteration? Did it allow for additional use that wasn't already there? And that was how I looked at that term.
Thank you.
I think that we are ready to hear from the appellant. You have 15 minutes.
Thank you. My name is Donald Mooney. I'm an attorney for Thomas Tryon and the appellant in this matter. And good morning, commissioners. A couple of things. I thought I would maybe even just address some of the comments that were made and then that were made by the planning director, and then jump into a little bit more of my prepared, but to address those kind of up front. One of the things that is not, the commissioner pointed out the word altered in there, but also reconstructed too. So when a trap house is reconstructed, or a new building constructed, or the concrete things constructed, that brings the code section in to effect. That makes it, that required permitting. And if the planning director had indicated that that the Calaveras County Code doesn't seek to eliminate or reduce the non-conforming uses, I would disagree with that. And if you look at California policy, and I talked about it in the papers that I submitted, the policy of the state when zoning ordinances are passed are to allow those non-conforming uses to continue to exist so long as they exist in their current format. But the overall policy of the state is to eventually eliminate the non-conforming uses over time and bring all of the uses to be consistent with the zoning for that land. Here, if you look at the zoning code, well, it may not say the goal of that zoning code, may not use the word eliminate non-conforming uses. But when you look at the language in there, the language in that code anticipates that as you alter it, as you reconstruct it, as you attempt to build new structures, you have to bring that use into compliance with the zoning. The language there indicates that the way the zoning code is written, the way this is written, indicates that the goal is to bring all of these parcels into compliance with the zoning code over time. Because not every parcel is going to, buildings will eventually need to be reconstructed in many places. They will need to be altered in order to accommodate uses. So that's the overreaching goal of not just statewide policy, but of the Calaveras County Code policy with regards to legally non-conforming uses. One of the things, building light standards, to put in new lighting. That is a structure. There is nothing in the code section about the definition of structure there that says it has to be of a certain size or of a building permit. You need a permit. It says it has a broad, as Commissioner Ladish pointed out, a very broad definition of structure. Again, that is to bring the uses into compliance with your zoning code. The way this has been interpreted is they can continue to do whatever they want out there. As long as they can continue to shooting as long as they want, and they can do whatever improvements they want on that property without ever any oversight by the county on those land uses. And that is simply not what the law provides, and that is simply not what the case law provides. With regards to the expansion of the use, the argument that it's just more customers. If they have more customers out there, then that's not really an expansion of use. That's just as if it was like a retail store. Well, it's not a retail store. It's a membership entity. They have expanded the use to evening. And I would actually submit that if you had a retail store, if you had a store that had been, at the time the zoning code went into effect, that had only been open 9 to 5, or you could even use, say, maybe if there was a racetrack that would be loud and noisy to the neighbors, and it only operated on Saturdays and Sundays. and then during the day. And then they decided that they're going to put lights in. And now they're going to have races on Wednesday evenings, and maybe Friday evenings. That would be an expansion of the use. And that is no different here. The expansion of the use, when you look at a legally non-conforming use, you look at the time of the use. For parcel 08, that date was 2000. So if they are expanding their use, if they decide to do shooting on Wednesday nights, and they weren't shooting on Wednesday nights, that's an expansion of the use. It's not the amount of customers, it's the intensity of the use. It's the expansion of the hours. Under the planning director's definition or interpretation, they could shoot at 3 o'clock in the morning. They could do a 24-hour shoot-a-thon. They are allowed to shoot 24/7. There is no boundaries to his interpretation and application of the zoning code with respect to enlargement. So, and I'd like to again also focus on the word altered. They are not allowed to. They're not allowed to alter. If there's any alterations to the structures or reconstruction of those structures, then they are no longer a non-conforming use. And I think state law also indicates that once you've lost your legally non-conforming use, you are a non-conforming use. I have a concern about that they could somehow try to go back to the way they were, because if they go back to the way they were, they're going to have to reconstruct buildings. They're going to have to alter their usage. They're going to have to do things that bring them within that code section. And once they're within that code section, they are no longer a legally non-conforming use. I'd also, both the staff report and the gun club's submittal, they both fully acknowledge that they have replaced the trap houses, that they have put in the concrete structures, that they have constructed lights. So none of that's in dispute. The burden in here, while we are the appellant, the planning director was correct that the burden is on the gun club. They have the burden to come to you and show to you that they have continued to operate on parcel 8 exactly as they have, that they have not constructed any buildings, they have not reconstructed any buildings, that they've not altered their usage, and they cannot show that. And they had and in their submittal, I point out that they had, while they described what they've done, there was actually no legal discussion as to how that remains a legally non-conforming use. There was no citation to case law. There was really no citation to even the county code as to how their reconstruction, their construction of light standards, how that brings them, how that keeps them as a legally non-conforming use. Absolutely no legal analysis or legal discussion with respect to that. And again, the burden is upon them in coming to you to show that, and they have not met their burden. And there was even this discussion of that they acknowledge that they have realigned the rifle range. Well, in realigning the rifle range, they put in backstop. That backstop is connected to the ground. By the definition that is structured, by the definition of structure, that is also a structure. So they have reconstructed, or they have constructed a new backstop. They have altered the use. They have altered the rifle range. Again, that brings them within the code, requiring compliance with the conditional use permit. And I would point out, Commissioner Laddish asked about the remedy here. The parcels 07 and 31, they do not allow shooting on those under their zoning at all. It is only parcel 8 that allows a conditional use permit. So the remedy would be if the commission, I'm on autopilot here a little bit. Y'all look very judicial to me. If the commission was to find that the uses on parcel 7 and parcel 31 were not legally non-conforming, that they were violating the zoning ordinances, the remedy would be for no longer use on there unless and until they were rezoned or the zoning ordinances were changed. Now, they could come to the commission or to the county and apply for a conditional use permit. And that's fully within their right, and that would be the remedy. But I think the remedy from the commission in terms of, and the county, would be if the commission was to find that they were in violation of the zoning ordinances, that there would be a cease and desist issued to the gun club, directing them to cease operations unless and until they bring that into compliance. And I'd also point out the way we got here today, and that was, I think, addressed in my letter a little bit, was they also require a permit from the sheriff to operate. That they are not exempt from, because it's not a zoning issue, it's a safety issue. They can't say, well, we're a legally non-conforming use, therefore we don't have to go get a permit from the sheriff. County code's quite clear that they need to get a permit from the sheriff's department. Sheriff's department.
Excuse me, I hate to interrupt, but I think you're taking up time on this issue that is not.
Okay, I appreciate that, but I just wanted to, that's kind of how we got here. And the sheriff has to make that determination about zoning and about compliance with land use. So, but, I will leave it at that. Tom, do you have anything to add? We've got about 2 minutes.
Good morning. I'm Tom Tryon. I'm the the complainant, I guess. Let me just start by saying, just reading the range rules, because I only have a minute or two. And on rules 2 and 3, in very bold print, the gun club says, and number 2, no one forward of the firing line until all firearms and grounds with the action open and empty chamber indicators are in place. Number 3 says no one will handle any firearm while anyone is forward of the firing line. If you go back to the map, the simple reality is on the rifle and pistol range, a third to a half of the Tryon Ranch is downrange. I don't know why we can't talk about the sheriff's letter, but the sheriff's letter says it's a hazard, it's dangerous, it's not safe the way the rifle and pistol range are configured. And I concur with that. And that's one of the main reasons we brought this action against the gun club. And Don's right. Right now, there is no oversight, zero oversight of the gun club. And if you put a list together of the things in the county that require a conditional use permit, the first thing you would have up there is a gun club that's shooting high-powered rifles, high-powered pistols, and 12-gauge shotguns. And the idea that they can shoot basically 24 hours a day, 7 days a week, because there is no constraint.
And the gun club has admitted that they shoot from dawn to dusk for rifle and pistol, except when they're shooting trap. But they can shoot trap now with lights. They can shoot all night long if they want, and there is not one constraint. Thank you.
Thank you, Tom.
I have some questions for council. For council.
Yes.
So what is the backstop at the rifle range, as you understand?
As I understand it, and I think there's some pictures that were submitted. It's, some boards that they put the targets on that they shoot at.
Okay.
And those are connected. I mean, there's some posts that go into the ground, and those boards are connected to the post, and they shoot at those.
Now, it seems to me the only issue before us today is, if you agree with what the planning director said is not under dispute, the only issue before us today is whether there has been an expansion of the structures or of the usage according to the ordinances that would take this out of being a legal non-conforming use. Do you have any issues other than that? I mean, do you agree that the usage did occur before the key dates involved, and that had it not changed at all, or the structures hadn't changed, that this would be a legal non-conforming use?
Yeah, there was shooting there before, on parcel E, before 2000, on parcel E, on parcel 8. I think there is some dispute as to whether or not the rifle range was being operated in its current location or its current alignment in 1986, because that's the date that applies to parcel 31 as well as parcel 7. So the gun club has the burden of demonstrating to you that they have not realigned that all of the rifle activity took place on parcel 31 prior to 1986, and I don't believe they have met that burden in their submittals.
Now, there's been some mention of development of roads, or at least improvement of roads. Do you feel that a road connecting two parts of a non-conforming use is a structure under the county ordinances?
Yes, and it's also altering the premises in terms of how it's being used. It's also probably allowing for the expansion of that use. The problem is that they've identified everything that they've done that actually falls within the statute or the ordinance. They've identified it as improvements. And the word improvement is not in that code section at all.
Peter, would you please put the ordinance back up on the screen, just because that's what they're talking about?
So it says, no building, structure, or use of land shall commence, be altered, or enlarged. Putting in roads is altering the use of the land. And it's altering the use of the land for the purposes of the gun club's activities. That brings it within the code.
Do you agree that the gun club had the right to use these parcels? I know you raised a question about ownership. Do you agree that they had the right to use these parcels for these uses before the key dates involved?
They had the right to use parcel 08, yes. They apparently would have had the right to use parcel 031. I think there is some dispute as to 07, that they were shooting. Obviously, there was lead shot falling upon it. I'm not exactly sure if there was actual permission at the time but they were using it. I don't, that would have to be, that might be within the documents that they've provided, I'm not sure.
And would you agree that the only issue before us today is whether, as to each of these parcels, is this still a legal, non-conforming use, where we're not determining any remedies today, are we?
I would probably agree with you the way that this has been brought to the commission, that if you determined it was illegal, if you determined that it was no longer, it's like a double negative on a double negative or something. If you granted our appeal and said that they are no longer in compliance with the zoning ordinance, one, I don't believe the sheriff can issue his letter, so they can't. So two, I think then it would be incumbent upon the county on code enforcement to then take action, because now code enforcement or the county has a determination from the commission that gives them oversight and says that this is not a conforming use, and therefore.
But that's the only issue before.
I believe you're correct. That's the only issue before you. Yes.
Thank you.
Before you go, could you go back to the...
To answer that partly?
That's between you and your counsel.
Okay. I think you're defining it too narrowly. I think the appeal was, is there a requirement, which was narrowly defined by the planning director, for the need for a conditional use permit. I think the appeal was not as narrowly defined as the planning director has presented. But is there anything in the record to show that the gun club needs to have a conditional use permit? And the answer is yes. And the two big issues that we're not addressing that would also require a conditional use permit is the sheriff's letter and the remedy that the sheriff advocates, which is a complete realignment of the pistol and rifle range. And the second is the lead contamination. And neither of those are being addressed here by the planning director. And the planning director had that information prior to the appeal. And those also have an effect on the need for a conditional use permit.
So I just want to kind of bring us back to the issue today. So the appeal can only be for the action that the planning director took, which was his determination of whether or not they were still in compliance. So all those other things might be things that could come before us if we were doing a conditional use permit, but right today, at this very moment, the only issue is whether or not the planning commission agrees with the planning director's determination. So just in the interest of time today, I would really love it if, I think Commissioner McKelly had a question. Do you have a question for them?
Well, the first question is to Mr. Mooney, and in your March 25th letter, you have quite a few exhibits. I cannot look you in the face and tell you I read each and every one. I certainly skimmed them all until I got to the very last one, 00. It's not there. Something about the noise problem.
Did I not include?
It wasn't attached to mine. And it wasn't, and the one I just received this morning didn't have it either.
I apologize.
Is that an issue? It's something about the noise level.
Yes, that was not included in my in terms of.
It's virtually your last paragraph of arguments.
And that is a draft report that we had done, and part of our argument was that if the county found it to be a nuisance, that if it's a nuisance, it is also it becomes a legally non-conforming use. And the draft noise study that we had done shows that it is over and above, and I apologize that was not included in my submittal. It might have just been, I didn't get.
Do you remember what levels of noise were found?
I don't. I have it on my computer. I can pull that up.
Right.
I apologize for that.
I had another question. Now I've lost it. Can we go back to let's say the latest plot map or photo. Can you tell me where the Tryon Ranch is in that photo? If it is?
The Tryon Ranch is where the arrow is, yes.
So that's the very corner of it. It continues around this parcel. This parcel here is a triangle. You can see the line going up. So it's a triangular shaped parcel.
Oh, all right.
Tryon Ranch surrounds that.
That's not 8?
And it's many hundreds of acres.
Where is it? Which one's 8?
This is 8
The main.
here.
8 is where the
It's the
traps are.
center, the main one. Oh, all right,
Yeah.
I had it back.
This is 7 where the pellets fall, and this is 35 where the rifle range.
But the argument was, or one of the comments was that the Tryon Ranch is downrange, at least partly.
Well, they
So-
shoot in the direction of, from here to here.
Okay.
So just the range, and then the trap, the pellets will fall throughout this area, but definitely not the.
Oops.
End of slideshow. Well,
So in that upper left corner is the Tryon Ranch. And
Upper
there's
left or upper right?
upper left,
Left.
where the yellow lines intersect in that
Okay,
little
all
corner
right.
there. That's the beginning of the Tryon Ranch. And there is, as indicated by the sheriff's letter, the way the alignment is on the rifle range, there's the risk of overshooting. There's also the lead shot lands on the Tryon property as well.
From the trap?
From the trap shooting, yes.
Lead can go that far? I mean,
Yeah, and
Shotguns?
there's significant, and in fact, the submittal that we did, that hopefully was in there from the RCC group, shows the lead on that 007 as well as on the Tryon Ranch property.
How many yards is it from the range's bench to his property line, and what's the topographical character of that property? Is it flat? Is it steep? Or
Mr. Tryon would probably be best to answer that. I don't know the distance. The distance between from the shooting of the rifle range to your property and the topography, the elevation.
well, also as to the traps, trap
yeah,
stations.
traps as well.
Oh, and the traps as well, the distance from the traps to your property.
Can you please come to the mic?
If you see the two big trap houses, and then there's two off on the right that are one of them by the yellow line, and then there's one off to the left. And the lead is that top horizontal line. It goes maybe 40, 50 feet beyond that top horizontal line.
What's the distance? What's the actual linear
Well, I
distance?
think they try to, on the rifle range, they try to make it somewhere around 100 yards, or as close as they can, because that's what people like to sight in. Something is at 100 yards. So probably from where the benches they're shooting to the backstop is approximately 100 yards. If you want to go to the corner up there, that's probably another 20, 30 yards or something.
So essentially, the shotguns are probably 120, roughly 125, and they're somehow able to get lead
I guess
all the way up.
I suppose that would be it. But you're talking rifles and pistols. You miss the backstop, which was the issue
Right.
with the sheriff. I mean, it just goes right out on the ranch.
Right.
Because that's pretty level, and if you go over that, then it's going to land out on the ranch.
Is
It's
your
going to
ranch
go way
uphill?
beyond their property. The shot from the shotgun range pretty much stays on their property, I think, except for up in that corner.
And what's the slope, or is it flat? Is it level?
Well, I think it goes up and down, but it's kind of, they try to get it fairly flat for shooting. So you're shooting across the ravine where the water flows, and so you get it. I think they try to keep it so there's not a big difference in elevation.
There are some photographs that were included in Mr. Tryon's attachment. The last two photographs, the second to last one shows, take a look, the view from his property looking down towards the rifle bench. And they're shooting somewhat uphill from there. Across a gully, there's a gully that sort of goes down this way. So they're shooting across the gully and then up towards the target. And then the backstop and the target is the black and white picture, was the last picture that was attached. You can see where it has been sort of cut into the hillside, and then just beyond that, where the trees are, is the beginning of the above property line. Those yellow lines on this map are not necessarily, they're close but not exact. And they could be off by anywhere from 10 to 20 feet. But they're a rough approximation of where the property lines are. They're just the assessor's map lines, aren't necessarily surveys. And we've learned from previous hearings that in some cases they're way off. In this case, I think they're relatively close. But I think those two pictures probably show you a good representation of what it looks like, the topography of the site. You asked what that was. So the top of the hill is a little beyond this image here. It's going up, and then it flattens out, and then continues on and down into another ravine beyond that.
So the black and white photo, the very last page of Mr. Tryon's letter of, it's actually December of 18. I guess it's an email, December 26 of 18. The black and white photo, is that the rifle range target?
Is that the rifle range target?
Yes, that would be the rifle range target. We obtained this map when we did the deposition for the president of the Angels Camp Gun Club, and I asked the attorney for the gun club, well, when was this taken? And he said approximately 1 year ago. So you can look back to see when the deposition was taken.
Is your
He
property?
said approximately 1 year ago from then, this picture was taken. Well, that's been totally reconstructed. I mean, that doesn't even remotely exist today.
So we don't have any current photos?
There probably should be some.
There's this one here.
Before we get to that, is your property shown on this black and white photo?
Is your property shown in the black and white photo? It would be a property.
Yes, the tree line back there is basically.
To the left side, I assume?
What?
The left side of that
Yeah,
photo?
straight up and to the left and to the right. If you look to the right, you can see a fence that's been put up, a new fence. You can just see the outlines of a new fence up on the right as you look at the edge.
The T-posts?
See that new fence going in a straight direction?
Okay.
Well, to the left of that fence then would have been Tryon property. And then there's a fence right above this backstop, right about the tree line. And then that's that corner that is referred to as the Tryon property.
Any other questions? Okay. Why don't we take a really short break, about 5 minutes, will that work? And then we'll move on.
5 minutes on our street.
Back to order. And is the gun club's representative ready?
Yes.
So let's get your 15 minutes started and let you talk.
Good morning. My name is Robert Ferrier. I'm an attorney. It's my privilege to represent the Angels Gun Club. I've been representing them for about 2 years here in Calaveras County Superior Court in a lawsuit with Mr. Tryon, where most, if not all, of these issues are currently being litigated. Now, that case hasn't been going to Mr. Tryon's liking, so without any notice to the gun club, he contacted the planning department and tried to wheedle out of them a decision that the gun club requires a conditional use permit. That initial decision, which was made by the planning department, which is certainly not in the pocket of myself or my client, considered all of the evidence, including the carefully selected evidenced by the appellant. And they came to the correct conclusion, which is the gun club has not enlarged its use on this property, that it is operated in fundamentally the same way since its incorporation in 1947. There were a number of astonishing half-truths thrust upon this commission, and I'd like to address a few of them right away. First, looking at this aerial photograph, if we look at the top left-hand corner where those two lines cross, that is not Tryon property. Mr. Tryon is fundamentally aware of this. That property was ceded to the gun club in a 1984 land swap, where the gun club ceded other parcels to Mr. Tryon so it could have that portion as a shotfall buffer. Mr. Tryon is aware of this. He's also been aware there's been shotfall, if you review his deposition testimony, since the 60s. Now he wants to repudiate that agreement because now he contends that he was not aware that the gun club was operating the rifle range in its present location. The rifle range in its present location and orientation has been operating there since at least the early 1980s. If you look at my submissions to the commission, and I've been at somewhat of a disadvantage because having to respond to the appellant, I don't know what he's going to present here. And I will tell you this, the environmental issues are at issue in the court case. I have experts who will come in and testify that contamination under California statutes means merely that lead is present, not that it's contaminating groundwater, not that it's causing an environmental problem. That is certainly not before you. As far as noise, that is not before you. But I have experts who are going to come into court and testify that the noise levels generated by the club are well within acceptable limits. The Sheriff's Department, when it wrote its letter, again, had no input from my client. That was Mr. Tryon going around the process and going around the litigation and trying to achieve a result that was favorable to him. When I responded to that letter to the sheriff, I noted to him that we'd had a nationally renowned gun safety and gun range expert review the club's operations, and he is going to testify in the eventual trial we will probably have in this matter that the gun range is perfectly acceptable for where it is and presents no danger to the surrounding properties. And I think prima facie evidence of that is the fact that this gun range has operated in its present form for over 70 years, and there has not been a single incident or single complaint regarding safety before Mr. Tryon. Now, Mr. Maurer, could you forward to the code sections? Now, I think when you look at the appellant's brief, when he cites 1792.020, you should take a very careful look at the portion of that he decided to cite to you, because this is part and parcel of the appellant's plan before this commission and frankly in the litigation before the Calaveras County Superior Court. He very carefully excised the last sentence of that section. The last sentence of that section reads, provided further that any damage or destruction to any structure associated with such non-conforming use is permitted to be repaired or replaced in substantially the same square footage as originally existed. If you take lights that illuminated the gun range since the 1950s, and lights over the course of decades of use in a wet environment deteriorate, you are allowed in the county code to replace those lights with operable and safer lights. You are also allowed, if you have to put a railing on a staircase because your older members are having trouble navigating the stairs to your clubhouse for the monthly dinner meeting, you're allowed to put a railing there because that is a safety issue. And I don't think the policy of the county or any legal body should be that we want to discourage property owners from making safety improvements to their land. The trap houses have been where they have always been. They have always had mechanical devices in them to throw clay pigeons. Those devices have always been under power. As they deteriorate, as the weather has an effect on those trap houses, yes, they were replaced in substantially the same square footage as originally existed. The gun club has been a valuable public citizen of this community for 70 years, more than that. Generations of Calaveras County residents have gone to the gun club to learn about gun safety, to get their NRA safety card. They have been operating in almost exactly the same fashion over that time period. They are allowed, if a structure burns down on the pistol range, to replace it. When you look at the code, you don't pick and choose your way through the code and find those sentences and those tiny clauses that you think support your opinion and your position. The code is meant to be read as a whole. When you look at 17.04.010, and it talks about the enlargement of use, next you look at 17.92.020 that describes what the enlargement of a non-conforming use or building is. I was absolutely astonished to stand here and listen to the assertion that a road is a structure. A road is not a structure. A road is separately defined in the code. It has a specific definition. To state otherwise is frankly misleading. The intensification of use portion of Mr. Tryon's argument may be the most spurious. I think I addressed it sufficiently in our brief, but the first thing you must know, Mr. Tryon, although he has been a member of the gun club for decades, has almost no personal knowledge of its operations. He has shot a weapon there 2 or 3 times in the last 20 years. When he comes to you and tells you that he knows that the use of the gun club has intensified, he does not know what he's talking about. There are several members of the gun club here who will come and make statements in the comment period who will explain that to you. As Mr. Maurer said, the use of the gun club property certainly has had its ebbs and its flows over the years. But its operation now, in 2019, is substantially smaller than it was in the 90s and the 80s and the 70s, as the character of Calaveras County has changed, and perhaps hunting and shooting sports have become less important in the fabric of the community. But they still do remain important to a significant portion of this community. There is testimony under oath in the court case regarding these issues. Mr. Verhalen, who is the president of the gun club, is present. Mr. Verhalen was deposed extensively in this case. And again, they have chosen to select tiny portions of that deposition to put in front of you and say, aha. Mr. Verhalen testified regarding the rifle range. I can tell you I used the rifle range probably in the late 70s, but for sure in the first part of the 80s, and it was where it is now. Question, now is the rifle and pistol range in the same location? Witness, yeah. You're going to hear that from other members of the gun club here today who actually have personal experience with what happened at the gun club, personal experience with how it is used. The club has far fewer members today than it has had at any point in its existence. All through the 90s, the gun club was full and had a waiting list. There are 200 empty slots now at the gun club, and there is no waiting list. The gun club throughout the 80s used to sponsor weekend youth shoots where, sure, many high school teams would show up and engage in trap shooting contests. That's a very rare occurrence now in the meeting minutes that the appellant choose to thrust upon you. And again, this is like going to a crowded cocktail party and trying to pick out your friends above the crowd. Those are isolated incidences of an isolated increase in use over a particular weekend. If you look at the history of the gun club as a whole, and again, there are people here who will give you testimony on that issue, the use of the gun club has deteriorated over time. The gun club is entitled to maintain its grounds. It is entitled, when a road washes out, to replace it with a better road. It is entitled, as it has, to communicate with the California Department of Water Resources and engage in a remediation plan to prevent and ameliorate the potential for lead or antimony contamination. And there is no credible evidence that anything of the sort is happening. As far as a public nuisance goes, and this is one of the very few accurate statements in the appellant's brief, to find that there is a public nuisance upon any parcel, the target property is entitled to due process of law. If Mr. Tryon believes that that is a public nuisance, he may amend his complaint in Superior Court and bring that claim before a tribunal and before the jury he is desperately trying to avoid. I have one final point to make, and I have to make it because of the comments and the emails that Mr. Tryon submitted to this commission. You know, he's never been content to simply let his attorney speak for him, and there's a few of those I take very serious issue with. And specifically, he decided he needed to impugn my character as well as Ms. Moss Lewis's. And I want to address that directly. I have dealt with Ms. Moss Lewis over the past year on several occasions. She is a vigorous advocate for the people of Calaveras County. We have had frank discussions and frankly bitter disagreements over issues in the court case. To suggest that she is somehow in collusion with myself to sway the opinion of this commission is spurious and should not have been advanced here. You can see there's a lot of members of the gun club here who want to address the commission and refute some of the points that have been made here. They have not been able to be heard throughout the last 2 years. They've had to rely on me to speak for them. Today is an opportunity for them to tell you from their personal experience what the gun club means to them and what has gone on there in the intervening years. And it's just my fervent hope that you listen to them and that you hear them today. And if you do, I think you're going to arrive at the inevitable conclusion that the gun club's use of these properties, all three of them, is a pre-existing, non-conforming use, and it is allowable under the code. And if you have any questions, I'm happy to address them.
Guess what? In going through the appellant's letter brief, he makes many claims of new structures having been added. Just as a blanket question, are you claiming that any structural work that has occurred, and by structural work I mean anything that's attached to the ground,
Sure.
That anything that has happened has been purely a replacement, a repair?
I am claiming that, and I'm claiming that all of that occurred to remediate or amend a condition that already existed before 1986 in the year 2000. You know, for instance, the concrete fingers that were put in, there was shooting going on at those sites because where the trap ranges are is elevated, and this is, you know, a wet environment. It, you know, was kind of a constant battle against nature to keep those spaces from deteriorating, especially if they were, you know, graded. So eventually they did replace them with very shallow concrete fingers to basically retain the shape and integrity of that site.
And would you say, I guess what I hear you saying is before there wasn't concrete, now there is.
No, that's not accurate. Concrete has been replaced as it has degraded.
Oh, okay.
Yeah.
Okay. Then I'm just going to run through these various things, and your members can also speak to the.
Oh, I think they're ready.
The lighting. Now, these are lighting standards, are there?
Are the lighting what?
What are there
Are they poles?
independent lighting poles that we're dealing with?
Yeah, there are. They were present before. They were a different kind of light. They were halogen lights. They used a lot more electricity, and they tended to trip the breakers on the club's breaker house. So eventually, they were replaced with more cost-efficient lighting.
And are there more lights now than there were before?
From what day?
If we're talking about
Technically, there's probably less lights, but they're more efficient.
there's more light but less
So
lights.
There's more light.
There's more actual light. There's not more light fixtures.
Okay. And they're not necessarily in exactly the same place as the old lights, but
No, the poles are in the
They are,
same
yeah.
place.
The same poles were used, just the lights were changed.
and the trap houses are in the same place as
They
they
are.
were?
They are.
Yes, trap 1, 4, and 5.
Sir, I guess we should ask for your name. So
David Verhalen.
I'm the current president of the gun club.
Thank you.
Trap 1, 4, and 5 was just rebuilt. When we did them, trap 2 and 3, we had hand-set machines. We had to have somebody in the house setting targets on there one at a time. It's fairly dangerous with OSHA stuff, rules, kids can't do it. We switched to automatic machines. Trap 2, trap 3, back in the 90s, were reconstructed. From the ground to the top of the house was this much, this tall. You could sit in there. The new automatic machines would not fit, so those were taken apart and reconstructed, so there's approximately 6.5 feet of height inside, so there's room for targets on the new machine. All the wiring and stuff was already there. You're talking about the concrete on trap 2 and 3 was repoured. There's some rules for trap shooting. The trap houses are basically 8 foot square and approximately 3 feet sticks out of the ground. The trap shooting field that everybody seems to not understand is concrete field. It's 16 feet from the trap house, from the front of the house, the farthest part of it away from you, and the 16-yard line. Fingers go back 27 yards. Those fingers are supposed to be flat. On trap 2, there was 2 feet difference in elevation in them. When they did it originally, they probably did all shovel work. It was actually higher than the clubhouse floor, so we had some flooding issues there. And at the same time that we rebuilt the trap house for automatic machine, we leveled that field and put the concrete back where it was, just lower in the ground. So we haven't really changed anything.
and I'll ask your counsel, if there hadn't been the pre-existing fingers, would you agree that the definition of structure in the county's ordinances would include the attachment of concrete to the ground?
Hang on a second.
Purely legal question.
And I don't think that I would. And the reason is that if you look at statutes and ordinances, if they were just meant to be mechanically applied, with no thought, then quite frankly, there wouldn't be a need for a commission. I think, the definition of structure is hugely broad, but if you think about the interpretation that council is urging upon you, I wouldn't be able to put a flower in the ground without being in violation of that definition. So I think there is room for the application of common sense and for, frankly, the appointment of a board that can interpret those statutes and a planning department that can interpret them in a way that makes sense. And council said something about statewide policy that I forgot to address, and I do want to address very briefly. Is he talked about, as a statewide policy, non-conforming uses being eliminated. That's simply not the case. It might be the case in Los Angeles. It might be the case in San Diego. It might be the case in urban environments, who are encroaching upon uses that frankly need to be abated because of rapid development. But specifically, the state has allowed counties to control their zoning and has allowed counties to have independent planning departments and independent planning commissions so that they can make community-appropriate decisions regarding the kinds of uses they want to allow in their communities.
Now, the history of the rifle range itself.
Yeah.
How long has that parcel 031, been used for a rifle range?
The rifle range has been fundamentally where it is since the late 40s and the 50s. When we talk about orientation, it was oriented in such a way that at some point it was actually pointed at an airfield. So in the 60s, they switched it. So it's oriented in the way that it is now. And again, we keep talking about, it's a rifle range, and I think that implies that there's multiple people down there at all times banging away. That's not the case. This is a single rifle stand with a single target and is used primarily for sighting in deer rifles. There was a point in time, as Mr. Tryon keeps contending, that people were using high-powered rifles, et cetera, and more of a target emphasis. Those members were asked to curtail those activities and leave, and now they're shooting at Mr. Tryon's gun range that's on his property, which I'm sure he hasn't brought up to the commission, but he operates his own gun range, which I don't believe he has either a conditional use permit for or a sheriff's permit for.
Now, as far as parcel 007, where the shot falls,
right,
through the years, has the gun club had permission to use that property for that purpose?
Definitely, and this was why it was the subject of the 1984 land swap. And until very, very recently, the gun club and the Tryon family were very cordial neighbors. They got along very, very well. Like I said, Mr. Tryon has been a member of this club for a couple of decades at least, and he testified in his deposition that he remembers riding out there as a kid and feeling the shot fall around him, because as the shot is fired at the traps where the shot position is elevated. So when it falls, I hate to use the term rain, but it doesn't have any velocity behind it. It falls something like rain. It's been falling out there for 70 years. It's a permissive use until very recently. Mr. Tryon has alleged that, I never would have agreed to this land swap if I'd known the rifle range was there.
But the gun club has had permission to use that property.
Yes.
Ownership aside.
Nothing that gun club is doing is a secret to anyone. I mean, I'm sure everyone's heard the firing here and there throughout the years.
And the rearrangement of the rifle range was just pointing it in a different direction?
Exactly. And
the gun stand was really in the same place, but...
It was. And
that happened when, the rearrangement?
As near as we can tell, that happened in either the 50s or the 60s.
Well before.
And if you look at some of the minutes that I provided to you folks when they're talking about the rifle range in the 70s and early 80s, what they're talking about is making a more formal, safer rifle range. I mean, primarily, the reason it's at 100 yards, or roughly 100 yards, is to sight deer rifles for deer season. I mean, that's almost the exclusive use of the rifle range, and it is by far the least used portion of the club's property. But it's been in substantially the same spot, pointing substantially the same direction for decades. There are sporadic mentions here and there to the realignment of the gun range. We can hear some testimony from the members here, but that's not referring to the direction of shooting. That's referring to the orientation of the targets, because periodically the shooting would damage the targets to such extent that they had to keep being replaced. And so they were trying to figure out a way that they could orient them that they wouldn't be clipped by a random shot and then they had to be replaced a couple weeks later.
Okay, that's all I have right now.
Does anybody else have any questions?
Yes, ma'am. Can we focus on some of the things that were just talked about?
Is your mic on?
No.
I can hear you.
There we go.
We're mic challenged today.
There was a discussion about the trap houses being rebuilt. And that was, at least one of the reasons was you had automatic machines being installed in a couple of the locations. And you used the word reconstructed.
That's correct. Would you like to go?
Sorry, I didn't catch the last name of the...
Verhalen. Verhalen.
Thank you. So the trap houses were reconstructed, whatever that means.
I can address that for you.
Rebuilt?
They were.
New wood, new foundations? What does that mean, reconstructed?
I can address this for you. And again, the first thing we should do is look at 1792.020. And if you look at, provided however any alteration or change in any structure associated with the nonconforming use shall be permitted if caused significantly by any government regulation affecting such use. Please remember that these are firearms. This is the discharge of firearms. In the 50s and 60s, I remember when I was a kid in the 70s, my parents let me ride along in the back of the station wagon with no seatbelts on, et cetera, et cetera. And I thought it was the greatest thing in the world to be sliding around back there when my parents, went around curves. In the 50s and 60s, we thought it was appropriate to have 13-year-olds out there, loading trap machines and throwing pigeons while active shooting was going on. Well, as community standards and frankly OSHA regulations and probably child welfare laws have changed, that's not appropriate. So what they did was switch, the structures to allow for fully automated machines that wouldn't put people in any sort of danger while active shooting was going on. I think if we look at 1792.020 in conjunction with 1704.010, that sort of alteration is expressly what's anticipated and contemplated by those sections if we read them in concert. If we want to talk about public policy, we certainly don't want a public policy that encourages people to maintain a use that may put people in some danger.
So your contention is that the new trap houses were required, that change was caused significantly by some governmental regulations.
Yeah, they were, and as Mr. Verhalen mentioned, specifically OSHA standards. I also think that if any county agency had gotten wind of the practice of sticking a 12-year-old in there like a Napoleonic powder monkey to operate the trap machines, there probably would have been law enforcement involvement. It's just an idea that in the 50s and 60s was fine. We finally realized, boy, that's a really bad idea.
Did this reconstruction of the trap houses also require wiring changes?
It did not require additional wiring. The wiring was already present. It's possible that, I'm not an electrician, I wasn't there, but if they had to, upgrade that wiring to meet with local standards, that was likely done. Again, we're talking about the 40s and 50s. That's old knob and tube wiring. They probably didn't require a ground. I suspect that they probably have a ground wire, things like that. But
what
again,
about the lighting, the light poles? Are they all? When were they first built?
It's going to be kind of impossible to fix that because nighttime shooting has been going on at the club since the 50s. The poles that are there have been extant probably since at least that time. It's the lights themselves that have changed. They've gone from halogen fixtures, which made that buzzing noise, and if they got wet, they might pop. They replaced those with more efficient fixtures.
And when did that happen?
The more efficient fixtures?
Yes.
I believe it was the 90s? Yes.
I saw somewhere in the paperwork that there have been quite a bit of recent changes since 2016.
Yes.
What has happened in the last 2 years or so?
We had the State Water Quality Board inspect our water, the drainage water flowing through the club. We passed all the tests, but we're not doing any polluting or anything like that, but the state and the federal government have a best practices book out there for things to do, and one of the things to do was to not have anything draining from a road or something we drive on directly into the drainage. So we have changed some elevations in those roads down there with base rock to have it run off into the grass where they want it to go.
And again, I would say that's squarely in line with permitted if caused significantly by any governmental regulation affecting such use.
I saw somewhere there was an abandonment of the lower road and a rebuilding or of a new road.
No.
The Gun Club Road itself, I think they were talking about. What is that all about?
The map back up.
The road that you see on the left, starting on the bottom, has always been there. It wasn't always rocked. It was just dirt, and there's a lot of shale there, so there's a lot of rock in the natural ground. There was always some base rock around the bench, which is over there on the left, about in the middle. And most of the work we've done has been from there down to the pistol and rifle range. There is a road that you could just barely see below the horizontal line from the pistol range to the right property line, and we abandoned that. We were letting rifle and pistol range guys go in there and shoot, and we had a lock on the gate. Within a 3-month period, 12 locks were cut. We were having trespassers go in there and use it, so we just put rock on the road behind the house, and now we don't have that problem.
Perhaps I'm misremembering it. I thought there was something about the Gun Club Road. Isn't that at the bottom of this?
Gun Club Road is barely on the bottom left of that screen.
And was that changed at some point?
Yeah, it's a county road.
All right. You were saying the recent improvements, and I suspect there were more than what you mentioned.
Yeah, there have been some improvements, safety improvements to the range. I don't think this will shock anybody. For example, if you have a pistol range and it's in place as this one has been since the 40s, you shoot over and over and over again into a dirt hillside. You dislodge dirt. It takes a while. The hillside gets rocky, and you should be aware too. This topography here is rugged. This does go up and down. This is not a flat plain with unimpeded sight lines for rifles and pistols into perpetuity. There's a very steep hillside right there. So from time to time, the gun club will come out and add more dirt to the hillside and remove some of the exposed rock so they can prevent ricochets and maintain the safety standards of the range. So yes, periodically there is dirt added. The gun club also, and this may or may not have been brought up, periodically mines the lead shot off of the parcel up at the top, both as a good environmental practice and really a method of recycling to take the shot out and they reload it. There's a service that does it, and this is a good environmental practice for a rifle range. And again, not to parse this too far, but it is strongly recommended by both the EPA and the California Department of Environmental Quality that happens.
Mr. Ferrier, can you tell me what improvements have happened in the last 2 years?
Last 2 years?
Yes, sir.
Adding dirt to the pistol and rifle range?
All right.
In the last, since litigation started, there's been, painting.
More base rock.
They've maintained the roads, as it's rained. They maintain the fencing, and people come up there and cut it sometimes. Like Mr. Verhalen said, they blocked access to that road because they were having trespassers. I guess that could be cast as an improvement.
That was before the last 2 years.
Yeah. A lot of it is, I would say, is under general maintenance. They do maintain the parking lot, make sure it doesn't wash out. You folks get a lot more rain than I do in the Bay Area.
Somewhere in these emails, I saw mention of an addition in the kitchen, something about kitchen repairs. What was that all about?
I have no idea.
I have no idea. Again, it's like, it's a commercial kitchen. They have to keep up with the relative.
The sterilizer had problems. Problems with the freezers and stuff have been repaired 2 or 3 times.
Yeah, some equipment's been replaced.
I think that what he's referring to is somewhere in the myriad of documents.
Yeah.
There was a description of alterations to the kitchen, which included pushing a wall out underneath an existing roof and porch line and then later in the documentation.
That happened a long time ago.
Yeah, I'm going to ask you a follow-up question.
Sure.
To this, but I'm just trying to clarify that. And then there was a later comment where in the minutes of the gun club, it said, the kitchen improvements were really great.
Oh.
So we know that they actually happened because somebody appreciated them.
Yeah.
So I don't recall the dates of any of that.
I don't know when
Mr. Verhalen.
the date was either. I've been range master for a long time, so the shooting is my deal, but things were done in the kitchen quite a few years back, and I can't tell you exactly when, but I'm sure the minutes would say.
So I think that the date that is most important to us right now is 2000. So can you summarize the work that has been done since 2000?
Since 2000 at the gun club?
Yeah, just a quick little list. I think, Commissioner Bekele, is that what you're trying to get to here?
Yeah, I saw somewhere in here where it says the last I thought it said 2 years, perhaps 2 or 3 years, there's been significant attempts to rebuild the club, to make it better, to attract more members, clean it up, meet the environmental requirements, whatever.
Sure.
I'm just not sure what that means physically.
Well, some of that I can address, and some of it, again, I apologize, but we had no idea what the appellant was going to bring up. I mean, there's other evidence that certainly could have been presented here today, but I'm kind of stuck punching in the dark because every time I turn around, there's a new claim. They've certainly done things to maintain and improve, the parking lot, the road that Mr. Verhalen has discussed. That's been regraded and that's had gravel added to it, but again, under the county code, that's not a structure. As far as structures go, I don't think there's been any major alteration of any what could be considered a structure since 2000.
So I'm going to make it really specific.
Please.
Since 2000, has any work been done that would have required a building permit?
No.
So no structures greater than 120 square feet, nothing off the ground, no alterations that change the footprint or the roof line of any building?
No.
No electrical?
When did the...
They put poles in the parking lot.
Okay.
I'm not sure when.
And were those replacement poles?
They were done by Gold Electric, so I'm sure it was a permitted deal.
Were they replacement poles, or was there lighting
No,
pre-existing?
there was no lighting there.
So there's new lighting in the parking lot since 2000.
There's 2 poles.
I believe that might be required now, but I'm not sure.
So, as a part of her question.
Sure.
If you don't mind.
Okay.
Those poles were attached to the ground.
Sure.
And at least by a strict reading of the ordinance, those would be structures. Has there been anything else where there was no attachment to the ground, where something has been added to the gun club and attached to the ground that isn't a replacement for something that was already where that was?
There's been, none of the trap buildings are in a different spot. 2 of them were rebuilt where they're at. The other 3, 1, 4, and 5 were there. We didn't change that, and we haven't reported the concrete on those either. There's no new building.
And if the commission were to decide that the gun club had to abate the poles, they probably would do it.
Commissioner Bekele, did that complete your,
Yes.
okay. Commissioner Henderson, any questions?
So the lighting poles in the parking lot, that was strictly for safety. Is that a government regulation that requires that?
It's possible. You know, if I had really had to guess, I might guess that the insurance company might like it. And they might like that the parking lot be modified in that way. I would also suggest that the club has a lot of older members. They have a once monthly dinner meeting that a lot of the members who don't shoot still come to as a social event. And, you know, it's a gravel parking lot. Parts of it can be uneven. I think it's safety improvement. But again, if you decide that it needs to be abated, the club will abate it.
Board decided to do that, and I can't remember when exactly, but after 2000, because I remember Kenny Snyder actually tripped and fell and broke his glasses and hurt his nose in the dark in the parking lot coming to dinner one night. So that's why that was done.
I have a couple more short questions.
Sure, go ahead.
Can we have the ordinances back up there again, Peter? So, as far as an expansion of use, 17.92.020, despite its title, doesn't really deal with expansion of use, but
Sure.
But 04.010 does, and specifically expanding the use of nighttime trap shooting to adding another night. Now, to me, that would be an increase that would fit within the word use being enlarged. Can you speak to that?
Yeah, I sure can. And I think it's important when you talk about an expansion of use, what you're talking about is a really broad snapshot that takes into account the conduct over a lengthy period of time. You know, shooting is allowed at the gun club during daylight hours. It's absolutely untrue that it's not restricted in some way. It's absolutely untrue that there can be shooting at the pistol and rifle ranges while there's shooting going on at the trap ranges. There have been periods of time where people, when trap shooting was more popular, they would come after work and do it. And throughout the 50s, 60s, and 70s, it's the reason the lights were there, so that people could turn them on and shoot. As the life of the club has gone on, as its membership has aged, and I can speak to personal experience from this, we start enjoying more sort of social aspects of our activities. And so, you know, the event on Wednesday is really more of a social activity. Yes, there's some shooting practice that goes on for the club. It's more of an opportunity for, I've been at these meetings, and with respect, it's, you know, friends getting together and getting after each other, but it's certainly not an increase historically in the use of the club.
So you'd read the word significant, sustained into that.
And again, I think this is what comes into where the common sense and the reason for a commission, you know, comes into play here. You know, if all we had to do was go ahead and just read this and say, oh, well, you know, on Thursday, you know, you had more people than Wednesday. So now this is a non-conforming use because the use has intensified. I think we'd all agree that would be an absurd interpretation. So I think what you have to look at is what was the use prior to the year 2000 and what is the use now? And is the use now more intense than it was before the year 2000? I think the answer to that is clearly no. You know, as again, this is not, I've never seen anybody at the club who's younger than me, and I'm not young. You know, so as that has taken place, the membership has declined, and the use, frankly, has too. The club is far less used now than it was in 2000.
My other question is, I just don't quite now, Peter, if you could go back to the slide with the ranges on it. Yeah. Now, the pistol range is what's up in the upper left-hand
Upper
corner?
portion, yeah, that sort of white square there. Yeah.
Where he is now? I mean, where that cursor, oops, sorry.
Oops.
Yeah. I mean, I guess my question is,
Right there.
yeah,
Right there.
I assume use of the pistol range and use of the trap shooting are mutually exclusive.
Yes. That's why there's a flag at the pistol range to be raised to say, hey, there's somebody down here. And these guys, I mean, again, on a personal experience, I had to have my own environmental guys go out here to take sampling from these fields. And my guy was like, look, tell them to go ahead and shoot away. They're not going to harm me here. And they absolutely would not do it because there was somebody downrange. This is not a bunch of guys out in the woods banging away at tin cans. You know, and I invite everybody here to come out and take a look at this place. It looks like the driving range at a country club golf course.
Okay, thank you.
Certainly.
Excuse me, real quick question. So the hours of shooting, what are your hours and days of shooting?
Yeah, please.
Okay, we have a league we've had for probably since the 70s, 49er Trap League. It shoots Tuesday evening starting at 6, Thursday evening starting at 6. Okay. I've been using the club since August of 72 when I moved up here. And I've been a member since 95 or 6. The league was huge back then. It was 39 to 46 squads. Okay. And we're talking about all this extra use. This year is 21 squads. Last year was 22 squads.
What's your hours of operation?
And the hours are, we start at 6. The last squad is up at 7 o'clock currently, and they're done at 7:30 to 7:45.
Okay.
In the past, last squads went up at 9 and we're done at 10.
Okay. Do you shoot 7 days a week, 6 days a
The
week?
trap range in the rest of the year is open Sundays at 9 until about noon, and the practice days were Tuesday evenings starting at 5. They decided they wanted to open up Wednesdays at noon, especially in the wintertime because of the light factor and the temperatures and stuff. So there's 4 or 5 people that shoot Wednesdays. And we also have a youth program. They shoot Wednesdays. They've been shooting there for many years, since close to 2000. And even that's smaller. When they started that program, it was 46 kids. I think we're 22 or 3 this year and last year. To give you an example of how much, we had a little deal. We didn't quite understand some of the IRS stuff, and we were having too much non-member money. We do strictly non-member stuff now. The difference, and last year we had a surprise shoot we threw for the youth organization that brought in about $15,000 that we normally wouldn't have done. But we're down $100,000 in trap range fees. Rifle pistol range, there's no charge for that. So we're down $100,000 as of last year's taxes. So shooting's not going up. The only shooting that might be going up is these days everybody wants a concealed carry, and they use the pistol range.
Okay, so your hours, have they changed significantly since prior to 2000 to now, or have they, your hours?
The only thing that would be new since 2000 would be the youth shooting program. And that program starts at 4:30 and is done by 6:30.
So I want to add to this question, please. It sounds to me like you have set hours for the trap shooting, but the pistol and rifle are sort of whenever somebody comes in and wants to use them, as long as trap shooting's not going on.
Right. We don't let them use, should take that back. I let my son use the pistol range while we were shooting trap, but he was on the SWAT team here. And
Well,
so that's the only time.
We're
but
really just trying to find out what's the earliest that you would allow
we try to
somebody
shoot from 9 o'clock or later.
Okay, so 9, and then what's the latest time?
You can't shoot in the dark, and there's no lights.
So it's pretty 9 to dark,
To dusk, yeah.
on 7 days a week?
Not when the trap range is
Right.
open.
Right, but other than the trap
Yeah.
range, yes, okay.
That's-
Is that
that's-
what you're trying to get
Yeah,
to?
kind of.
Yeah, that's,
And that,
hang on one second. That's correct, but it should also be emphasized that the pistol and rifle range are not used nearly as often as the trap range. And, you know, the trap range, you can only operate the trap range when it's supervised, and they have a range master there.
there's always somebody there when we go and play targets. A couple other things I needed to address. When opposition said about the backstop for the rifle range, he was describing...
Mr. Verhalen, can you hold that thought for just 1
Sure.
minute? And would you like to take a seat, and we will start the public comments
Sounds fine.
with Mr. Verhalen. So come on up, and you have 5 minutes to tell us what you want to tell us. And then we may ask any of you to come back and have more questions later about it.
Okay, what he called the backstop is a target stand. And behind that is several hundred yards of dirt piled up. So the backstop, and it's not, the elevation from where the target is to the top of the hill behind it is probably in excess of 50 feet. The elevation from where you stand to shoot pistol range with the backstop behind that is probably 15 feet over your head. So unless you're trying to shoot something that you can't see, these things are just not going to happen. Okay, and there's always, bullets are destructive, and so the backstops erode from the bullets, and they erode from just the rain, and so they're constantly being added to. When we talk about the sheriff not signing off, I requested they came out there, and he sent his range master out there, and we passed as far as safety-wise, as far as post inspections go. And the only problem was there was between the rifle range and the pistol range, on the top of the road there, we had a pile of rock about this tall that we had separated from the dirt for the backstop for the rifle range that we hadn't put someplace else, so we had to take care of that. So as far as I knew, we passed, and then I got real sick in December, and all of this stuff happened that I was not aware of. So if you have any questions other than that for me?
Anybody have any questions?
Yeah, there's some mention of this agreement or a deed of land from the Tryon Ranch.
Okay.
Can you expand on that and tell
Yes,
me
I
what
can.
that's exactly?
I was not there then, but from what I understand, that is about when they put in Trap 1, Trap 4, and Trap 5. And the reason they did that was they wanted to throw registered targets, which is, there's a couple associations, and 5 traps are required. So they made an agreement with the Tryons. There was a land swap, which I'm told is legal, but it was never done, and my understanding was that it was never dealt with because the Tryon property was in the Williamson Act. And I now know, of course I wasn't involved then, that it could have been done, because with the Williamson Act they couldn't sell off any small piece of ground, but it was just a lot line adjustment. If you look at that map, that line that goes clear up to the top actually goes out 1,200 feet. That's ours, 1,200 feet out there. And so what we had done in the adjustment was to go from the right corner that you can't see to probably 100 and some or 200 feet to the left corner you can't see on that horizontal line, and square up our property and then not cut their property in half with that 1,200 feet. We also have in writing an agreement to drop with the Tryon family that Tom signed, his folks signed, drop shot on the ground in exchange for grazing rights.
Is any of that in any of the papers? Is it in writing at all?
Oh, yeah.
I can just address this briefly. Yes, it is. There's a signed contract. I believe I actually provided it to the planning department. This is also part of the subject of the litigation in Superior Court. We've filed a quiet title action to try to resolve this in an application for a prescriptive easement. You know, again, I didn't know this was going to be a substantial issue here today. I also could have brought several copies of board minutes where Mr. Tryon talks about how he's just fine with that land swap and has no problem with it, et cetera. His recent about face is very recent. I also believe County Council has a copy of all.
Do you know if that land swap is referenced or mentioned in any of the exhibits that you attached to your brief that we do have?
You know, I don't believe that it is because, again, I didn't know that this was going to be a substantial issue here today, and I apologize. But again, I'm in the sort of odd position of being the person to defend the property owner, but I have to guess at what the complaints are going to be when I turn up at the hearing. You know,
So the answer is no. We don't have it in front of us. Okay.
But the planning department does.
I see Mr. Maurer looking through the file rapidly. Perhaps he can tell us later, or...
If it wasn't included in the package of attachments to the various briefs, then you wouldn't have it. I don't recall getting a copy of that, although I could be wrong. There's been a lot of paperwork that has been back and forth.
I can have it sent to you almost immediately. Go ahead.
So to be clear, it's parcel 7, I believe, that we're talking about.
Yes.
Okay. And that there was a land swap agreement, but it's possibly never completed.
It
wasn't recorded with the
It was
county
not
recorder.
recorded, I believe.
It was not recorded because at the time the parties believed the Williamson Act would provide a barrier to that. Now we know that's not the case. And there was no reason to because the parties were getting along.
So there was an agreement, it has not been recorded.
Right.
That's the situation right now. Okay.
And there's a quiet title action filed.
Okay. So, time's up. How many people would like to speak to this issue? Okay, let's get the next person up here. Please sign in, state your name, and you'll have 5 minutes to tell us whatever you think is pertinent.
My name's Steve DeFew. I've been a member of the club for 18 years. I'd like to address the vice chair's a certain issue he brought up earlier about 2 hours ago. I'm thoroughly confused about how you've thrown this word enlargement around a lot. Are you implying that even though it's been reputed that the membership's down and the use is down, that if, for example, 6 or 7 other men shot on a given evening, that is an enlargement of the club?
I'm not implying that at all.
What was your...
My question was, what does the term enlargement mean in the ordinance?
Well, I think that you did imply something like that. It was ambiguous because how else would anybody else interpret your question?
I'm not going to get into an argument with you right now, and I don't think it's to your benefit to get in an argument with me.
Oh, I'm not trying to get an argument. I'm trying to get an answer from you. You're the one who brought it up.
I'm trying to interpret the statute, and I'm asking questions as to what the statute means.
So let's just do a hypothetical for you.
Yeah. Excuse me, sir. So I think what you want to speak to here, if you're supporting the gun club, is can you provide any additional information to us that would support the idea that there has not been a change in use?
So what you're telling me is that I cannot question something that somebody on the board mentioned?
You may, but that won't help the issue.
All right, then I'm going to stop. I'm going to stop. I just want to echo something that was eloquently brought up by the attorney here.
Sure.
And he used the word, the gun club, as a citizen of the community for the last 70 years. I thought that was really important because Mr. Tryon used that citizen or the gun club for his personal use and identity when he was a political figure in this county. And I don't want that to be gone, not recognized, okay? This gun club has been a citizen of Angels Camp and the county of Calaveras County, and I would like everybody here to have some common sense and recognize that.
Thank you.
Could everyone please sign in so I can get your name spelled correctly?
Greg Meyer, I'm from Copperopolis, and I'll put my address down. I just want to say you've been very thorough today with your questioning, and I think it might be reasonable to think that if there's no remarkable or extraordinary discovery here, that you wouldn't go against the planning director's determination in this. And that's my hope anyway. And I'd like to point out something that I wasn't quite aware of, and you're the experts on this, and it's kind of related or directly related to this. The gun club's been around since before 47. 61 is when the county decided to start providing a land use map and zoning. And of course, that's when this all was agreed upon to be existing and go forward. But I just, when we had a break, I see that the land use map out there has 3 different land use designations on it for these 3 parcels. And one of them is probably the appropriate one. It's commercial recreational, one's commercial and one's resource production. I think it ought to reflect the use that was existing here since 1947, the uses on these parcels, so that in the future, when we're discussing these items, at least the county has recognized what's happening, historically and presently. So, thank you.
Thank you. Anybody else?
My name is James Castle. I'm a 3rd generation member of the Angels Gun Club. My sons are 4th generation. I've been a member since 1973. In 1962, I went and took my hunter safety class prior to becoming 12 years old. We went down to the pistol building. We shot 22s. We went through a fence. We learned how to safely handle firearms and everything. And prior to the hunting, that was in April or May, hunting season back then started in September. I went to the rifle range with my father and I sighted in my gun. So those uses have been where they're at since that long ago. Okay, my grandfather and my dad helped build the gun club. I've been a member, I've been a director for about 25, 30 years. And so I don't see that we've tried to, most of the improvements we've made since I've been a director in the last 25 years. And most of them were made for safety. When we replaced the trap houses, we built them in there. We didn't completely tear them up. We cut the tops off, raised them up so we could get the height and everything we needed. But we didn't just destroy everything and start all over again. There was no reason for it. We put drains in because when they filled up with water, if you were unloading, you get electrocuted. So we thought maybe we wouldn't want to do that. And that's basically what's happened. I know there's other guys that want to speak, but I can tell you that we never tried to do anything other than to make it safer and easier for people to use it. Thank you.
Hi, my name is Russell Maduro. I live in San Andres now. I've been an Angels Camp my whole life. And my dad put my name on the new member list in 1974 when I was 18. And when I was 21, I was just reachable to get into the gun club. As for the rifle range, I'm going to tell you, if you overshoot that target area, you violated every rule anybody's ever taught you when you're shooting. Not to mention common sense. You have to try to overshoot that rifle range. As for the trap houses, I was one of them Napoleonic monkeys that was asked to get in there. It was like a ritual for us in the middle 60s as a teenager, and we volunteered to get in there. Don't think too much of that. We got free hamburgers and hot dogs, so it was a big thing for us to get in there. But I can still remember going to school on that Monday morning, looking at the size of that thumb when that guy forgot to take his finger off that trigger, and I got whacked good. So raising those houses on those trap houses was a really good thing. Thank you. I watched too much C-SPAN. I'll yield my time back.
Good morning.
My name is Rick Parker, R-I-C-K, P-A-R-K-E-R. And My wife and I moved to Angels Camp in 2003 after I retired from law enforcement, lieutenant, investigations, SWAT team commander, Hayward, California. I've been a member of the gun club for approximately 9 years, going on 10. I've shot twice on the rifle range. Both of those were to sight and a scope on a rifle at about 100 yards. I've been to the pistol range primarily, and I don't shoot trap, although I'm interested in it. I have been to many ranges during my career. So when I went to this range, especially the pistol range, I was very impressed with the way it's set up, its target configuration, and the background behind it. In that photo right there that you're looking at on the pistol range, very lightly discernible is a line there, and then above that line is a whiter area. That whiter area is the elevated background for that pistol range. That dark line that goes across that is where you configure the targets. He's pointing to it right there, most pistol shooters will shoot between 7 to 15 yards. That's pistol shooting. Once in a while you'll see somebody go back 25 or 30, but they're just really trying to practice controlled pistol shooting. I take my wife up there. In fact, we were up there 2 weeks ago. And every time that I've been there, people who go there, including me, usually look from Gun Club Road down to that range. And usually you can see if there's someone down there, if the range is occupied by anyone. And I've noticed that everybody that drives down that road and approaches that range when someone is there usually stops, slows down, and waits until that shooter has cycled through their fire. And then the shooter will usually turn back and acknowledge the person in the vehicle. They'll drive around, and before the shooter, this is my experience, will start to shoot another round of fire, they'll turn and look at those people that are coming on the range site there and make sure that they have ears on. And it's just kind of a common courtesy. I've noticed that up here with everybody that I've seen at this range. Regarding the gun safety issue, someone mentioned they're not just out there playing cowboy and Indians. Everybody there that I've seen has been very disciplined. Regarding improvements, I know my time's out. Since I've been there, the only improvements that I've seen is maintenance to the road and maintenance to the target area where bullets have impacted, where you have to hang the targets at the pistol range. Thank you for your time.
Thank you. Is there anybody else who would like to speak to this issue? Sign in.
Hi, my name is Mike Borian. I can't write and talk at the same time. Test a couple things, the longevity of the gun club. I used the gun club for the first time, 69 to 70. I was a Boy Scout. We took hunter safety course out there. And the first time I handled a shotgun at the trap, and then we went out and climbed through the fences with our 22 rifles and shot at the rifle range. So I'm a grandfather of 3 right now, so it's been a while. I'll let you guys do the math. The thing about the gun club, it's integrally woven into the fabric of our community. There's, I'd say, thousands of people like me who did a hunter safety course out there. It's been a big part of the community for a long time. And to see it under threat is concerning to me, because this is one of the things that make this a great county to live in. And as far as the activity goes, I am a member now. I've been a member for about 4 years. The reason I'm not longer is before it was a 5-year waiting list to get in. And the minute I heard there was openings, I got in. And I'm one of the guys who shoots at the arc that's closest to the trap houses, because I'm not very good at it. I'm horrible at it, in fact. But the dinners you go to once a month, and I make them every 3 months, it's just neat to go there, and the history and the community spirit that I feel in that room, even though I don't know a lot of the people, is just something that I want to see maintained. And the last thing I want to point out is that the whole reason this is under threat right now is because the neighbor wants to change his property use. I understand he wants to develop his property into housing development. And for that to happen, he has to eliminate this current property use. So our rights as a community, as members of the gun club, are being threatened by somebody else's desire to change their property use. Thank you for your time.
Thank you. Anybody else?
My name's Clay Dillashaw. I've lived in Angels Camp for 64 years, been a member for over 40 years, and I was one of those 12-year-olds that loaded trap. And so I'm very familiar with the gun club and its history. When I was 12, I loaded trap on Friday nights, and it was all lit and whatnot. So it's been going on for a long, long time. And as far as a pistol and rifle range, I do not remember them not being there. So when they went in, I don't have a clue, but I don't remember them not being there. Thank you very much.
Thank you. Anybody else who'd like to speak? Okay. Oh, one more?
Good morning, Commissioners and staff. My name is Tim Utertes, District 3. I am a member of the Gun Club. After you've heard all the testimony and you've heard all the public comment, you are going to be asked to ignore current regulations. You're going to be asked to ignore precedent. You're also going to be asked to ignore the advice of your planning director, who brings 30 years of expertise to the table. You're going to be asked to allow an individual to twist and manipulate the system for his own financial benefit and gain. Please do the right thing. Thank you.
Okay, one more time. Gone. We'd like to take a 10-minute break, and then we'll come back to Peter, and you can have whatever comments you have, and then we'll come back to the appellant. Yes, thank you. Thank you, everybody. Let's get our mics back on. Thanks. And would the appellant like to spend about 10 minutes, actually not more than 10 minutes, rebutting anything that you take exception to?
Oh, a few things, yes. First, I'll take exception to the characterization of how we got here, and that, yes, there is litigation going on, but we're not here because we're unsatisfied with the direction of the litigation. We're here because, as part of that litigation, we pointed out that they do not have a permit from the Sheriff's Department. And I know, the permit is not the issue necessarily here, but that's how we got here, is because they had to go to the sheriff and ask the sheriff. They realized that they've been operating illegally without the permit from the sheriff. Sheriff had to make a determination about whether or not they are compliant with the zoning, asked the planning director to do that. So, and that's how we got here. We didn't get here because we filed some action with the planning department. It's they had gone to the sheriff to try to bring themselves into compliance with the county ordinances. I wanted to point out there was some discussion about the realignment of the rifle and pistol range, and they said that took place in the 50s and 60s. Their own minutes, however, contradict that, indicating that realignment has taken place since then. I think the Exhibit H that I provided indicated that there was a realignment since the 2000. Exhibit T talks about the rifle and pistol range had trees removed to make way for the realignment of the pistol range. So there has been realignment of the pistol and rifle range. I think it was Exhibit H had indicated a realignment of the, I'll find it here in a second. And then in 2014, Mike Shore is to mark trees to be cut for the realignment of the rifle range. So there has been that realignment has taken place since 2000. Also, there was I believe it was in Exhibit U, in ours, there's a newsletter where they talk about, there's either newsletter or minutes, that they talk about participation has greatly increased. So it was from March 2015.
Participation in what?
It says Range Master Dave Verhalen assumed management these past few years, and the trap range is busiest even during some of these colder months. And Dave Verhalen assumed management these past few years, and participation has greatly increased. So their participation appears to have been going up in the last few years. I'd also point out that council had indicated he didn't submit some information because he wasn't sure what the appellant was going to do. These are different proceedings than, say, a judicial proceeding. But also, I'd point out that the burden is upon them. They have the burden of proof in this proceeding in terms of maintaining that there is a legal non-conforming use. So that information, if they had information to support that should have been submitted in order to meet their burden of proof. There was also in Exhibit L, it talks about the lighting of Trap 1 is completed. It doesn't talk about lighting of Trap 1 has been redone. It just says it's been completed. So it does appear that maybe there's some additional lighting that might have taken place. There was also some discussion in our papers about new roads being put in. Again, this is altering the use of the land and expanding the use of the land. Tom, if you have a few comments. My 10 minutes went very quickly. Or was that 10 or was that 7?
It was only 5.
Oh, okay. Go ahead.
Thank you, Annette.
Peter, I'd like to bring these three up, and maybe you can find those while I give a comment, and then I'll comment on those three. Thank you. I would just like to point out that all the testimony you've heard from the gun club says they're just running a wonderful operation, and their operation should continue, and there should be no oversight, zero oversight of the Angels Camp Gun Club. And yet, they're all down here, and why are they down here? They're down here to oppose the imposition of a conditional use permit. If you go to their webpage, it says to all their members, they sent it out to all their members, says please show up at the board meeting or commission meeting today and support the gun club, that this is a plot. This appeal is a plot to destroy the gun club. Well, if everything is all right with the gun club, why wouldn't they be more than willing to do a conditional use permit? I mean, if this is the outpouring of how we're doing everything right, then why the fear of a conditional use permit? I mean, they should be embracing a conditional use permit and come on in and look at our operation, and let's have public hearings and let's have a discussion of what appropriate conditions would be for the board or for the commission and then the board to approve a conditional use permit. So having said that, note on this picture that the rifle range backstop is to the right of that corner. Will you put up the, let's see, you got my pictures.
I don't have them on slides here, but in your packet, there are 3 pictures that Mr. Tryon asked.
Toward the back,
for.
I'll give them back. Okay.
First one is the first picture attached to the letter from...
If you could go to this one, it's at the back end of your packet with all the pictures in it.
We have quite a few packets. Are we talking
This is the packet from Mr.
Of my
Tryon,
response.
the Tryon letter?
Dated March 25th. It was received date. It says from Tryon Ranch at Gmail, subject country club.
Or I can hand it.
It's an email to his
And you can pass it down so everybody can just look at it. All right, Peter, maybe just let them pass it down.
We've got it.
I'll call it.
It's in the stuff you handed out earlier today.
You find it?
The December 2018 one.
Which picture, page would that be on?
Okay.
It's about in the middle of the big,
Yeah, I found it.
Right.
Got it?
Yep.
Gentlemen, you gentlemen up with the lady? Okay. Well, look at that, and you can see the corner here. And that corner is the corner that's right above the backstop there. And if you look at it, you can see that where the rifle range now is, it's to the left of that corner. So I know for certain that the rifle range has been totally reconstructed, but it's been moved also, I would submit, assuming that, these lines are accurate. It hasn't been moved far, but it's been moved. Do you see what I'm referring to here? See where the and if you look at the rifle range down here, the backstop, those should not be sticking off the top of the backstop. Those look like they took bowling pins and put them up on the structure of the rifle range, and we're using them for targets. And if you look through some of the other pictures I've given you, you can see down at the pistol range where they're shooting at golf balls and they're shooting at aluminum cans. And then I'd like to go to this picture. Maybe I think if
that's the very first picture in that
you'll
same
come
packet.
to this picture. And you can see where they put up a new fence. And I talked to somebody at the gun club, I don't remember who, I said, why'd you put up this new fence? And they said it's to keep the cross-country team out. Because the cross-country team used to run, or still runs down the railroad track, and then they do a loop, and they'd come back through this gate and do a loop back to the railroad track, and then go back to the barn. So the question would be is why, and picture was taken in 28 January 2017. Well, why for all these years was it safe for the cross-country team to run through here, for Tom Tryon to drive through here? You can see they fenced off my gate. I just cut the fence because I have a right to use the road. The reason is because they totally reconstructed the rifle and pistol range, and the amount of uses has increased dramatically. I mean, they're shooting rifles. When they're not shooting shotguns out there, unless it's a bad weather day, you generally have somebody at the rifle or pistol range shooting. It didn't used to be that way. You have Dave Townsend's letter in there, the range master that retired in 2011, saying how they rebuilt the pistol range and how both the pistol and rifle range had very minimal use. Well, it's not minimal use today. Thank you.
Mr. Tryon, could you come back to the podium for a second? I have a question. Can I, if that's appropriate?
Yes, go ahead.
Thank you. We really didn't talk about these various pictures other than the ones you just did.
Well, I'd like to, but I don't, it's time.
Right. But I can
So ask me and
but I can ask
let's
questions.
go through them all.
Can you tell us, when you say there's significantly more activity,
You have to
does that
speak
mean
up
it's
for me.
sound?
What?
Is it the noise that you're noticing? How do you know that there's more activity?
Well, I drive that road all the time. See where the gate is there, where my dog is?
Okay.
I drive that all the time. And so it's not just the noise. Yes, the noise is a big issue, but it's the safety. You know, it's just what the sheriff said in his letter. It's a safety issue. It's not safe to be downrange of the rifle and pistol range.
So is there some spot on this slide that you can show where you drive?
Do you have another? That one doesn't show very well. Peter, I get back there or not? Can you get another slide showing sort of the same thing?
Unfortunately, I did not load all of the exhibits, everything into the packet. The road is just slightly to the north of this image.
Is this north-south?
Map where my road is.
This is.
North is up, so it runs along the top of the, up here.
Oh, I envisioned it as east as the north, that's the top. So that's north at the top.
Well, am I allowed to go up to the map or not? Yes?
Sure.
I think so. Can you?
The road I use, you can sort of see it here. If you come up to here, you can see it. You can see there's a road coming right through here. It comes right on down, and it goes off to the part of the ranch that's on this side. It's not a long piece, but it's a road. We've used it all the time. The railroad tracks right over here.
Tom, if you could come back and speak at the microphone so that we get what you say on record.
What?
If you come back and use the microphone,
Oh,
that would be pointed out where the road is.
That's the road. And the reason for the appeal, I mean, if nothing had changed since 2010 or 2008, I wouldn't be here. That's not the reason for the appeal. The reason for the appeal is everything changed. I mean, they've basically effectively condemned probably a third or a half or more of the Tryon Ranch by what they're doing right now. And the increase in usage, particularly of the rifle and pistol range. When this first started, I asked to speak to the board of directors of the gun club. I went and spoke to the board of directors of the gun club, and I said, I can't live with the rifle and pistol range. You've got to change it to where you're not shooting, well, the Tryon Ranch isn't downrange. You've got to change it, and that's exactly what the sheriff said in his letter. And I looked at the board of directors. Most of them were nodding in agreement with what I said. And then I talked to the president afterwards, and he said, well, we haven't made any decisions, etc. And then he called me again, I don't know, a couple weeks later, and we met, and he says, we're not going to do anything. And I said, well, then you only leave me one choice, and that's to get an attorney and go to court. And he basically shrugged his shoulders, and I went off and got an attorney and went to court, and here we are. But to say that nothing's changed since 2010, and really, it's probably the last 3 years. I mean, there's been huge changes out there the last 3 years. And that fence just tells you how significant it is and why they did it. I mean, they didn't do this before, and we all traveled freely on that road.
Is there another location they could move the pistol range in particular? I'm not talking about the rifle, but the...
on both. You could just turn them around to where the backstop is facing the Tryon Ranch. Just turn it around. Make that where you shoot from and shoot back to where you're shooting from now.
Is that a hill?
You could do that.
Is that a hill up above the clubhouse, or what is that topographically? Where the rifle range is located, the shooting location, is that above the clubhouse?
I'd say...
Is there a hill there? I can't
about
tell.
even with the clubhouse.
It's same level.
What?
Same level, same height.
Well, it's not going to be exactly, but I'd say it's somewhat close. I don't think it's way off at the same height.
All right.
Mr. Pichelli, the property slopes down into a gully that runs right through here. So there's a fairly steep drop off from the trap shooting area, and then it climbs back up the hill. The elevation is pretty much the same, but there's a fairly significant gully between the two sites. So this would be shooting downhill in this direction. As you know, right now this is shooting downhill.
Could the pistol range be turned to the side, going towards the east?
There's probably any kind of changes that could be made, but that's really not what's before us today. It's whether have there been changes that have been made. If we get into a situation where they're proposing modifications to it, we can look at that, but that's not what's really before us today. Yes, there's probably all kinds of different ways it could be rearranged. But again, we're looking at, is this a legal non-conforming use, not what is the best arrangement of the shooting range.
Thank you.
Any other questions for me?
Madam Chairwoman, may I address the commission real briefly, if he's been getting all this extra time?
Actually, you're going to get an opportunity, just one moment.
Thank you.
No more questions for Tom?
Actually, Mr. Mooney, could you please, you keep, Peter, can you move back to the color, please? You keep using altered, and I looked up altered. The definition is to cause change in character. Are they changing character, causing change to the character of the gun club?
Well,
who are you addressing?
Mr. Mooney.
I would submit that they are changing the character of the gun club if what they're doing is altering it in a way that allows for the increase of use, which Mr. Tryon just had indicated, that allows for additional night shooting or better access to the rifle range or the pistol range. That would be altering it in a way, yes.
But the character of essentially since 1947 has been a gun range, correct?
It has been a gun range since 1947, portions of it, yes.
All right, thank you.
You got any questions?
No, sir, thank you.
Mr. Maurer, can you return to that slide we were discussing?
You have 10 minutes, and then we'll have an opportunity to ask more questions.
It's difficult for an attorney to be that brief, but I'll try. Yeah, I think the important thing to realize about what Mr. Tryon is talking about, the top edge of that property, that's unequivocally gun club property. Mr. Tryon has been granted access to that to manage his cattle. He doesn't run cattle anymore. He has
Are you talking about parcel 7?
Yeah, the parcel that's above the sort of K-shaped parcel there. That's the road. Mr. Tryon just testified, and what we have all long suspected, that he periodically cuts the fence so he can drive his truck onto that parcel. Part of the litigation in Superior Court is an injunction because Mr. Tryon has made it his habit to drive onto that parcel because he knows the gun club won't shoot while he's out there. So he drives out there, not for any legitimate purpose, but to stand there with his dog, talking on his cell phone so the gun club can't operate. Because they are committed to safety and because they are reasonable people, they wait till he leaves. But he quite often disrupts the gun club's operation in a purposeful fashion, frankly, spiteful fashion. The gun club does not need the sheriff's permit. We thought that it might ameliorate some of Mr. Tryon's concerns if we had the gun range inspected by an independent third party. When that independent third party first came out, they thought there was no problem. It was only after Mr. Tryon, grabbed that person by the lapels and started haranguing them that suddenly they changed their mind. Again, this is an issue that's being litigated in Superior Court right now. And again, to emphasize, there hasn't been any incident involving the gun club of anything being harmed. Commissioner Henderson, I think you hit it right on the head. The alteration, to be an alteration, there has to be a change in character. I would direct your attention to the bylaws and the mission statement of the Angels Gun Club. The shooting of pistols, rifles, and shotguns has been part of the club's DNA since its founding. These were the sons of Calaveras County who went off to fight in the war. And they came back to Calaveras County and they wanted a place where they could get together socially for the most part and enjoy the activities that at that point were a real part of the fabric of this community. And certainly gun ownership is part of the fabric not only in Northern California but but the American West and ranching. And I was talking with someone outside right before we came back in here. Essential tenet of the West, and I'm proud to call myself a Westerner, is that if I'm not hurting you, you leave me alone. The gun club isn't hurting anybody. They haven't hurt anyone. They've been a benefit to this community for almost a century. They don't need a conditional use permit because fundamentally their use of these parcels has not changed. The rifle range, this idea that it's been reoriented, it's been this, it's been that. I addressed that earlier in my statements to the court in the statements from the 2000s talking about the reorientation of the gun range. That's a search for a target that would not degrade as quickly as the targets that were there previously. The rifle and pistol range have been where they are fundamentally. The pistol range since the 40s, the rifle range since at least the late 50s and certainly the 70s and early 80s. There has been no fundamental alteration of character of this club or the use of these parcels. You've heard the testimony from the people here today. They have firsthand knowledge. They told you how the gun club is operated. They have told you where these facilities were. This is the first time in 2 years, all this litigation, all this fall for all, they've been able to be heard. You should listen to them. Take them seriously. They have the right to come to their government and be heard. That's just fundamental to our freedoms. This claim that the club is a non-conforming, illegal non-conforming use is spurious. The evidence that they've presented, this is the only client I think I have that runs a club or frankly any organization that actually does take minutes at every single meeting. It's kind of amazing. There are hundreds of pages of these minutes. I think they've produced 2 or 3 that can somehow be twisted to imply that the rifle range is something new or that there's been a sudden explosion in the use of the gun club. When you say something like that in a newsletter, I think we've all been members of an organization that has a newsletter or a bulk email or whatever. Typically, there's not a lot of gloom and doom in those publications. There's not a lot of, everything's terrible and things are going to fall apart. No, they're generally optimistic and say, hey, things are going right. We're going in the right direction. We're your board. Please vote for us next time the elections come along. I'm happy to answer any remaining questions in the time that I have left, or I can sit down and quiet, which I'm sure everyone.
Oh, no, we need to ask a question.
Sure.
I very much appreciate that you had your membership come today because you have the burden of proof.
Certainly.
We needed to hear not just summaries and allegations from counsel, but we needed to hear
I felt that was very important.
However, I'm going to ask you now to summarize.
Sure.
In answer to appellant's claim that the use has increased and continues to increase, particularly since 2010.
Yeah.
Now, we've heard about there are fewer teams competing on the trap shooting thing, but could you summarize what we've heard today as far as your evidence that the use of the gun club as a gun club is not enlarged during the period?
Certainly. And I think the first thing you should look at is when I cite in my brief is the membership of the gun club itself. And you heard some testimony directly on this point today is that, before 5 or 6 years ago, there was a waiting list that was 5 to 10 years long. Now there's 200 separate places for people to join the club. You heard testimony about the size of the youth program and how that has diminished over time. We haven't added an additional rifle bench. There hasn't been an expansion of the pistol range. It's to some extent I'm trying to capture sand as it runs through my fingers. But I think if there was an expansion in use, you would see that reflected in the footprint of the aerial photographs that have been provided by the planning department. to really summarize what's happened, this went from being a collection of friends and well-wishers in the late 40s and then became a pretty well-organized large club in the 50s and 60s. As the character of Calaveras County has changed somewhat and has moved from predominantly mining, ranching, logging, all of course which are still viable today, it has also become substantially more suburban. The population centers have expanded. You've had a new wave of, I'm going to call them immigrants, coming into this county who probably did not grow up with a rifle rack in the back of their pickup truck or missing a day of school because it was the first day of deer season. So just generally as the character of Calaveras County has changed, the interest and use of the gun club has diminished. What I told you earlier about the average age of the gun club member, I think if you polled it, you'd find that it was probably well north of 50. It used to be that there were a very robust youth program. It used to be there was a very robust youth competition. That's all gone by the wayside. This is just not the way people grow up anymore.
Are there still youth competitions at all?
Sporadically, and the gun club takes that very seriously and takes gun safety very seriously, and so it will make its facility available. I believe there's a competition team at the local high school here. They do practice there. They practice on Wednesdays. But the size of that squad, if I'm correct, is 10 to 12 people. It's not the 40 or 50 it might have been in the 70s or 80s. This is just not the concern it was in the 70s, 80s, or 90s, as the character of the county has changed and people's lifestyles have.
Now, an easy question.
Sure.
Right above the pistol range there, is that the start of parcel 007?
Where that line is there?
Yeah.
Above that, yes.
Okay, so that's the one where you have indicated that Mr. Tryon will drive his truck across. That is part of parcel 7?
Yes.
And, okay, thank you.
No problem.
Commissioners? Yeah.
In Mr. Mooney's brief, his March 25th letter, he has an Exhibit X, which appears to be a copy of an email in 2019 from Dave Townsend talking about improvements made during his time as range master. A new backdrop was built at the pistol range in 2010. In 2011, the lower road was abandoned and an old road off of Gun Club Road was graded and graveled into the pistol range. We had some discussion about that, but I'm still not clear on exactly which road was abandoned. It's lower. To me, I'm thinking lower on this picture. I gather that it's really the right-hand faint road. Yeah, that one. Is that the one that was actually abandoned?
No. Peter, can you go up?
Oh, there it is.
Oh, up there.
There it is. Oh, there you go.
And that was in 2011.
Yeah.
Yeah, that's the road there. Goes right there to the property line.
Right. And
we had roads down there from here and across below here, the trap one, and over to here there's a culvert and goes to there. And those were the main ways. And there was a road here that wasn't perfect, but it got graded up and rocked, and that kind of solved the problem.
Yeah.
I need to say something about the rebuilding of backstop in the pistol range, which is exactly here. And when we mine the shop, and the shop is all mined from all of this area here and back to here. The only flat thing down there is where people stand to shoot at the pistol range in the front of the rifle target. And so all all of the separation of the lead from the dirt and the rocks was done there. And all of that dirt had to be brought down, so the whole back of the backstop for the pistol range was removed for the equipment to get through there. And the pistol range was closed for months. And when it was all done, we're talking about reconstructing it, that's what was done. Now, whether it was put, I wasn't the range master then, I thought I had retired. And whether it's 4 feet wider or 4 feet taller or 4 feet to the left, I can't tell.
Okay.
And it's the same with the rifle target area. Those posts are steel posts. They're put in concrete. Occasionally the knuckleheads shoot them and break them. And I can guarantee you that when they dig new holes, they're not digging through that concrete. So they're going to move that target to the left or the right or back or something. It's that basically within feet and inches, that's where everything is.
So let's go back to the road issue.
Sure, this road right here.
I thought the roads were these white stripes.
They were, and the thing with this road is that people who are not members of the gun club, I mean, if you go out there, it's, calling it a road is probably generous, but the problem with it is that the public could skirt the locked gates at the gun club and access the pistol range down here. So people who are not members of the gun club were using that and cutting the locks on the gate to get in here and shoot the pistol range. And so that's what the gun club wanted to stop, was to stop access of people who were not members using the gun club at random times they weren't supposed to. So that's the measure they took to block this road off.
I actually had the ex-undersheriff's mother in that shooting one time, wasn't a member, and we're shooting trap. I went down there and she told me she had every right to shoot. I threw her out anyway with 2 other guys she was with. So.
There you go.
Like I said, it's out of sight, out of mind. So anything, if someone's doing farming work, you would not notice that road down there. And like I say, 12 locks in 3 months were cut, and the combination locks, and so they just decided to take that gate out, put fence up there.
Okay.
I'm trying to focus.
Sure. Yeah, please.
What is the new road? Is it that white colored stripe?
There's not a new one. The roads have been graded and improved so that they will sustain traffic and not wash away.
Peter, can you show us the earlier?
Right here.
Yeah.
There you go.
All right. Okay.
There's a better picture of it right there.
All right.
And so, they wanted to block access to this so that people who were not members of the gun club couldn't drive down, this road over here and then get into the gun club and use it on off hours or whatever. I mean, I would submit that's good stewardship.
So the question, I think, is the road to the left, right, is the one that was improved, the long one that goes...
Yes, and that's improved again because, as you people are aware, there's a substantial weather out here.
Can you show us the very first photo, the oldest photo?
Yeah, so it's got to be right in here somewhere.
So it's never been something that's been under substantial regular use.
It said somewhere in here it says trees were removed in this process also.
Give me that.
The rifle benches is here. The target's here. And you can see a trail where if they didn't walk down the road to get down there, they had that sort of trail to get there. Well, we had a bunch of oak trees and stuff in there, and we actually had members putting targets on the trees.
Which is obviously not ideal.
And not only does it kill the tree, but then all of a sudden we don't have a proper backstop. So
right.
Trees were removed from that. But I got to tell you, I wasn't range master for all of those years. When Townsend was there, I trained somebody in camp. His mother got sick. They got Townsend, and like I said, the shot deal was fine. I set up the line, and like I said, they had to destroy the pistol range back stop to do the lining, and after it was done, that's a rebuild.
I think
we'd like to move it to the right.
I think it's important to realize too is that when Mr. Tryon talks about these areas being the Tryon Ranch, they're not. There's a substantial drop off up to the north over here, and it should be mentioned Mr. Tryon doesn't live out here. Mr. Tryon he doesn't run his own cattle out here. The only reason Mr. Tryon comes out here, from my understanding, is when he wants to interfere with what the gun club is doing. As far as trying to prevent the cross-country team from running across this parcel, I think that's an excellent idea to discourage that kind of activity. And unfortunately, it's again my understanding they were invited to do so by Mr. Tryon, who didn't frankly alert them to the fact that, hey, there's an ongoing gun range going out here. So the gun range had to take its own measures to go ahead and stop that. And, I think, again, that's an example of good stewardship. I'm a little surprised to hear Mr. Tryon come here and admit that he's been coming out there and cutting the fences himself.
I think we're kind of getting off
We
topic
are.
at this point, so thank you. And do we have any other questions?
Not for me.
Really? That's great. I have one question.
Certainly.
I am still confused about Parcel 7. Parcel 7 has no physical gun club improvements on it, but it is where the overshot goes.
That's where the shot falls from the trap
Yes.
range, yes.
So, Parcel 7 is the parcel in question that there is a purchase agreement but no recorded transfer? Is that the case?
No.
Okay.
This one is gun club property. The parcel that was part of the
Is
land
that-
swap is here.
Okay.
And if you go out there, which is difficult, but if you go over this way a little bit and over this way a little bit, you will find posts that mark the line of the gun club property and have signs on them. It is only in the last couple of years that Mr. Tryon has now asserted that he retains an ownership right in that parcel.
Got it. That's, I think, what we were trying to figure out here. Exactly. That's very helpful. Thank you. Any other questions of the public, of the applicant or the gun club? Peter, do you have any questions for Peter before he starts his little wrap-up?
Well, at some point, I want to ask him a question.
Okay, yeah, let him.
Well, I don't really have anything else to say unless there are questions of you. I just, again, the decision here, there's a lot of sort of peripheral issues, but the question is whether or not my determination that this was a legal non-conforming use, they didn't, back up to the words, there was no enlargement or alteration that would constitute expansion of the use, and therefore there was not a need for a conditional use permit, was the finding that I had made. And the question before you is whether or not that was the correct finding based on all the additional evidence that you have received here today, as well as all the written testimony that was presented.
Okay.
So I do have a question of him then. Parcel 8, as I understand it, is zoned recreational. Is that true?
Yes, that's true.
And that's the K-shaped parcel.
Right.
It has virtually, most of the equipment and everything of the gun club is on Parcel 8.
Yes, this parcel here.
But the zoning regulation requires a conditional use permit for a shooting range.
That became effective in 2000.
In a recreation
recreation
zone. And how do we avoid that or not require a conditional
Well,
use permit?
because the use was established prior to that requirement. So the use of this site was established 1947, I think that was stated, my understanding. And the question of, so we first enacted zoning in 1961, I think it was. In 1987, we adopted a significant revision to that zoning code that established the permissive standards, that if it's listed, it's allowed, if it's not listed, it's not allowed. At that time, the recreation zone allowed for hunting and fishing clubs. And in 2000, and some of the attachments that was provided in the addendum to you, the ordinance was changed and shooting ranges were pulled out from the general description, even though it was not really clear, based on the correspondence from staff at that time to the Planning Commission and to the deputy director of the planning department, what I could glean from that was that the county considered a shooting range a part of hunting and fishing clubs. And so it was a use that was permitted by right in the recreation zone up until the year 2000. And so that is why we're looking at any changes to the club from 2000 on this parcel. The other two parcels do not have the rec zone. One's unclassified, one's commercial. And they, the prohibition on shooting ranges or hunting and fishing at that point was effective in 1986. So that is why there are different dates for the three different parcels. Two of them have 1986 as the key date, and the main parcel was 2000 when hunting and fishing clubs was changed, and shooting ranges was specifically drawn out as a use requiring a use permit at that time.
And is the request by the appellant, was the original request to cease and desist the entire operation of the gun club permanently? Or was it a request to get a conditional use permit?
The request from Mr. Tryon initially was for me to determine that a use permit is required, that it was not a legal non-conforming use. And so I've been doing some investigation on it. There wasn't a lot of information. I then received a request from the sheriff's office whether or not this was a legally permitted use for Title IX determination. And that's when, again, I came up with the determination last fall or last December that it was a legal non-conforming use.
The only reason I ask is because I heard some of the members saying, or at least one mentioned today, that Mr. Tryon was trying to shut it down completely.
I do not know that for a fact.
Right, okay.
Any further questions of Peter before we close the public hearing, or of any of the folks who have testified? So we're going to close the public hearing and have some discussion among the commissioners. Tim, I'm sure you have something you'd like to say.
I have a few things to say. I found this a very hard case. And coming in this morning, I felt that the gun club had a heavy burden of proof to prove that there has not been an expansion of both of the structures and of the use of the property, so as to satisfy the burden of proof that there is a legal non-conforming use that is continuing. And part of what I considered to be their burden was the very tough definition of structure in the zoning ordinance that basically put anything you stick in the ground is a structure. But the testimony we've heard, the comments we've had from the membership, and the arguments that have been made on behalf of the gun club have convinced me that we have a legal non-conforming use here that is continuing. I think some of the major factors in that is that the structures that have been replaced or repaired or altered in any way, that this has been done in order for the gun club to keep its same use of the property. Many of them are for matters of safety. Many of them were required by regulations the gun club would just have the choice of either being unsafe or being in violation of federal regulations if it were to not make these changes. I don't think it's to the benefit of the public to require an organization to become unsafe under the current standards of the community, just in order to maintain its status as a legal non-conforming use. The question as to whether the land use, and I'm looking now at 17.04.010, whether land use had been enlarged or altered, is, I think, appropriately looked at as somewhat of a zero-sum game of not just whether any particular use at a particular time has been changed or increased, but whether the use overall, the gun club use of any of these three properties, has it been enlarged? I was bothered by the fact that the Wednesday night shooting was added, but I have been convinced from the comments that have been made today that overall the gun club has less use now as a gun club through its diminished membership, through its diminished participation in youth programs, and fewer trap shooting teams. We've had some specific evidence that the gun club's use as a gun club is not enlarged or altered in any significant way. So with that in mind, and looking at each of the parcels involved, I think I'm convinced that it's a legal, non-conforming use, and I would deny the appeal.
Commissioner Kelly?
Thank you. For once, I'm going to disagree with Mr. Gladish, but I'm not necessarily saying that the gun club has done anything wrong at all. You guys are model citizens in general. The gun club itself, I think, should be under a CUP. I'm not saying it should be shut down at all. You yourselves have said you have certain hours for operation, you have certain rules, regulations, and yet there's also some evidence that there are people who come onto the gun range and shoot illegally, whatever. There's some evidence that the shot has overshot onto adjoining properties. It may not be quite as safe as we all think it is. And so I really don't understand why a CUP is so bad. And Mr. Tryon, as far as I can tell, has not tried to shut it down, except to get a CUP. And like he said, get together, try to get some reasonable rules on it, and get this over with. I think there's an immense amount of money being spent on, sorry to the lawyers in the group, but there's, two of us up here. I think common sense could and should prevail, and you folks can get together and solve this problem without us having to be the bad guys. So I'm going to vote the other way. I would uphold the...
Now, is that as to each of the three parcels? Because two of the parcels, the CUP is not available.
That's true. As to parcel 8, you're right.
Well, no, the mechanism for expanding a use is through a CUP. So if the use was established before the zoning, which it was, unless you determined that there was no use of those parcels prior to 1987, then the remedy for allowing the expansion would be through a CUP, regardless of the zoning.
Yeah.
If it were a new use, yes, it would have to be rezoned before we could consider a use permit. But because this is an existing use, and if you find that it was existing, then it could be done to a CUP.
Essentially, I'm finding that it's been altered. I think that's the word that I focus on.
Commissioner Henderson?
I've heard, listened and heard everybody's argument and points. What I looked at is the history of what was going on there since 1947 or prior, before it was formed into a gun club. And looking at the improvements that the gun club has made, I don't look as improvements or changes. I look at if they're changing a trap house to improve safety so that children or kids are not getting injured or have the opportunity to get injured with new technology or whatever comes about. I don't see that as a reconstruction or change. I think it's just an improvement in safety, and quite frankly, as we go through, we become a society of laws and regulations. So hence, since 1947, there have been regulation changes, and there will continue to be regulation changes and new laws, which we will have to adapt to and change things that have happened in the past. So I believe that this is a legal, non-conforming use, and that's how I see it. Thank you.
So I also found this a very difficult item to look at. There's just a lot of information, and I am sympathetic to some of the arguments that there should be oversight of certainly of a shooting range, and in a perfect world, this project would have a CUP and there would be oversight, and I think that would be easier for everyone, including the sheriff. However, in looking at the totality of what's here and in reading and rereading the portion of the ordinance that applies to this, I think that I have to agree that this is a legal, pre-existing, non-conforming use. One of the reasons is when we talk about use here, in any part of the zoning code, it's talking about an expansion or an enlargement of a land use, not of use. And so I don't think that the time and days of operation really come into play in this decision. And it also seems like it would be difficult to have a very large increase of use when you have a decrease in membership, although it's possible that some of those members are way more enthusiastic and they're using it at different times and hours. But in looking at the totality of what is in front of us, I just have to agree that this is a legal, non-conforming use. So I would uphold the determination of the planning director. Does anybody else have anything to add? Are we ready to have Peter read to us the actual wording of what we're going to vote on?
So staff recommends that the Planning Commission adopt Resolution 2019-009, denying the appeal by Thomas Tryon of the Planning Director's interpretation that the Angels Gun Club is a legal non-conforming use.
Any discussion?
Yeah, actually, would you believe, even though I'm very hungry, I would like to have a short break to consider, because to tell you the truth, I came in without this being the result that I was going to be voting for, and I'm not sure I agree with it every way that it's been stated, and I'd like a few minutes to...
You'd like a break?
A break.
Okay, could we take a short break, 10 minutes? Thank you, everybody.
Well done.
Peter, do you have a resolution for us to consider?
Yes, so the draft resolution that was presented in the staff report, Commissioner Laddick has suggested some changes which I agreed to. On the second page, under finding number 2, I'd like to revise that to read, the structures and use have not expanded since 2000. And then strike the finding and evidence number 3, but add to evidence for finding number 2 the following 2 sentences. Improvements to structures were made for the purpose of safety, regulation, and repair, period. Since 2000, there has been a decrease in use and club membership. And those 2 statements would be added to the evidence under number 2.
On the other thing, this is your usage. The third whereas, should the word in the last part of the sentence be permitted rather than permitting use? That's up to your expertise.
That it should be permitted.
Yeah, I had that circled also. Ready to hear the whole thing read to us?
Well, I think I already did that in the recommendation, so I think you're ready for a motion.
Okay.
I would move that we adopt the resolution as amended.
Second the motion.
Any discussion? All in favor?
Aye.
Aye.
Aye. Any opposed?
Opposed.
So the motion carries. This action is final unless it is appealed to the Board of Supervisors within 15 calendar days. And the appeal will be filed with the Planning Department.
Thank you, everybody. We are going to move on to our next item, which is action items, which we don't have any. No informational items, no study session, any commissioner reports. Planning director report.
I don't remember if I mentioned this before, but the draft housing element is available for public review. I guess I didn't mention that either, so I have nothing more to report.
Then we're going to adjourn. Go have lunch, everybody.